Yes, Mr. Hodge.
Commissioner, the next witness is Mr. Cohen, and Dr. Higgins will call Mr. Cohen.
Yes, Dr. Higgins.
I call David Anthony Keith Cohen.
Would you go into the witness box, please, Mr. Cohen? Would you prefer to make an oath or take an affirmation?
An oath, please, Commissioner.
Yes. Swear the witness, please.
I swear by Almighty God
I swear by Almighty God
that the evidence I shall give
that the evidence I shall give
will be the truth,
will be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Thank you, Mr. Cohen. Do sit down. Yes, Dr. Higgins.
Your full name is David Anthony Keith Cohen,
Yes,
and your business address is 201 Sussex Street, Sydney.
that's correct.
And you're presently Group Chief Risk Officer of the Commonwealth Bank of Australia.
Yes, that's right.
Have you received a summons to attend the Commission hearing today?
I have.
Do you have a copy of that summons with you?
I do.
I tender the summons, Commissioner.
Exhibit 3.110, summons to Mr. Cohen.
And you have prepared two statements in relation to Rubric 313, Mr. Cohen.
That's correct.
The first is dated 17 May 2018 and addresses questions 8 to 34 of that rubric.
That's correct.
Are the contents of that statement true and correct?
Yes, they are.
I tender that statement and its exhibits, Commissioner.
That statement, dated 17 May 18, with respect to questions 8 to 34, I think
Yes,
you
Commissioner.
said, Dr. Higgins, will become Exhibit 3.111.
And the second statement, Mr. Cohen, is also dated the 17th of May 2018 and provides supplementary evidence in relation to questions 23, 29 and 30 of Rubric 313.
That's correct.
Are the contents of that statement true and correct?
Yes, they are.
I tender that statement and its exhibits, Commissioner.
Statement 17 May 18 in relation to questions 23, 29 and 30 and accompanying exhibits, Exhibit 3.112.
Do you have a copy of those two statements and the exhibits with you in the box, Mr. Cohen?
I do.
Mr. Hodge will now ask you some questions.
Yes, Mr. Hodge.
Thank you, Commissioner.
We're going to run out of real estate in the witness box unless we're careful, Mr. Cohen. Before we begin, can you get yourself in a position where you feel comfortable that you've got access to whatever documents you need?
Thank you, Commissioner. I think I'm right.
Yes, Mr. Hodge.
Thank you, Commissioner. Mr. Cohen, the first issue I want to deal with and take you through is some documents relating to Project Magellan. So we're going to start just by going through some general issues in relation to the history of that project.
Certainly.
And you've given some evidence in your statement about that. What I want to do is show you some documents that aren't exhibited to your statement, and you may or may not be able to comment on them. Can we bring up first CBA .0002.2076.7461? So this first document is dated the 25th of March 2009, Mr. Cohen. What I'm going to do is I'm going to just step through a number of documents starting from about this period of time. I just want to so in that temporal context, I just want to put in context what your position is. You're now the Chief Risk Officer of the Commonwealth Bank, is that right?
Yes, that's correct.
Back as at March of 2009, what was the position you held then?
I was the Group General Counsel of the Commonwealth Bank Group.
And you never worked for BankWest?
No, I did not.
Did you have some involvement in the acquisition of BankWest by the Commonwealth Bank?
I did, yes.
In the sense that you were no doubt advising them as part of your role as General Counsel?
Initially in broad legal capacity, yes. And then secondly, and more specifically, in the actual negotiation of the acquisition documents.
And after the acquisition was completed in December of 2008, you then had some involvement in relation to the expert determination in relation to the price adjustment mechanism.
Yes, I did.
And beyond that, what involvement, if any, did you have in BankWest?
The next level of ongoing involvement with BankWest was in connection with the surrender of BankWest's banking licence, which was in effect a requirement of APRA following the acquisition.
And that happened in 2010 or 2011?
So the actual surrender occurred in October 2012, but there was a lot of work for about 18 months or so leading up to that point.
And the issue, as I understand it, was that APRA's preference was that there be only one licensed ADI within the group. Is that right?
That's correct. That was its policy at the time.
And one of the issues that you needed to work through was that legislation in Western Australia seemed to require BankWest to hold its own ADI. Well,
That's correct. That was one of the tensions between APRA's requirement that BankWest licence be surrendered and BankWest's ongoing compliance with the Bank of Western Australian Act.
And ultimately that was resolved?
Yes, ultimately the Western Australian government passed some amendments, or the Parliament passed amendments to the Bank of Western Australian Act.
And that, to be clear, had absolutely nothing to do with Project Magellan?
No, it was...
And it was just an issue between the tension of the requirements of APRA in relation to how many ADIs you could have within a group and the legislative requirements of Western Australia?
That's correct.
And there was an issue which was whether or not APRA would continue to allow certain concessions that allowed you to take into account Commonwealth Bank capital in relation to BankWest. Is that...
Not capital, no, but Commonwealth Bank funding of BankWest. So one of the conditions that in effect APRA waived for a period was that Commonwealth Bank could fund BankWest to the extent of 30%, which was above the normal level that APRA would have allowed for one ADI to fund another ADI.
And but for that concession, it would have been necessary for BankWest to go to the market to raise capital or something like that?
It would have needed to go to the market to raise debt funding, not capital per se, but debt funding, yes.
But as it was, that issue got sorted out.
Yes, that's right.
So then if we come back to what was going on in 25 March 2009...
Sorry, Mr Hodge.
Oh, I'm sorry, yes.
Is it possible for me to look at a hard copy of the document? I'm finding it hard to read it on the screen.
I'm not sure how practical that will be.
Okay.
We'll do the best we can. We'll try to blow it up for you, Mr Cohen, and if we can over...
Commissioner, we have copies of these documents if it assists my
that would
learned
be very
friend.
helpful.
Very well.
Thank you.
Now, one of the things that you explain in your statement is that there are a number of re-examinations of the portfolio of BankWest.
Yes, there were various reviews carried out.
But you weren't involved in those reviews.
No, I was not.
You've gone back and informed yourself looking at the documents that are available.
That's
to
correct.
you. All right. And I want to just take you through a timeline then of what happens in terms of those documents. You see, or you're aware now that one of the issues that was identified relatively early after the acquisition of BankWest was how much of BankWest's total committed exposure was in commercial property.
Yes, I'm aware now, yes.
And what's set out in the second dash under portfolio structure is that commercial property was representing 50.3% of BankWest's total committed exposure for the non-retail assets.
Yes.
And in addition to the level of exposure, there was also an increase in what are referred to as troublesome and impaired assets.
Yes, that's correct.
And perhaps if we just take those concepts separately, could you just explain the way in which BankWest and CBA defines an impaired asset?
Yes, an impaired asset is an asset in, for example, a loan, where the bank does not expect to recover the full proceeds of the loan. So it expects to make a loss in respect of that loan.
And a troublesome asset is what?
A troublesome asset is a level of risk grade that is not as serious as an impaired asset, but it is an asset where there is a concern about the health of that loan, and it derives from a view that the likelihood of loss from that loan has increased.
Now, this document, is it one that you've reviewed in the course of preparing to give evidence? Or you're not sure?
If you can just give me a minute, I will tell you I've looked at thousands of documents and I just need to familiarise myself. I believe it is.
All right. But it's not a document that you've exhibited, it's not from within the selection of documents that you've included as part of your
That's
statement?
correct,
All
yes.
right. So these are other documents that the Commission has identified, and we're now going to
Yes.
take you through that.
Yes.
And the point about the increase in troublesome assets, you can see that made in the second last dash under key findings. You see across all sectors there has been a notable increase in the concentration of troublesome assets over the past 9 months.
Yes.
And then if we go to page .7469, which is page 9 of 15 in your hard copy version,
Yes.
Mr. Cohen, and you see there's chart 15, which is impaired assets, and IFRS. What does IFRS stand for?
That's an accounting standard.
Specific provisions, and we see that in the preceding year there'd been a 3 times increase in gross debt for impaired assets,
Yes.
and also that over the same period the value of specific provisions against assets had increased by 13 times.
Yes.
And could you just explain to the Commissioner the distinction between general and specific provision?
Yes. A specific provision is, or sometimes known as an individually assessed provision, is a provision made in respect of a specific loan, taking into the circumstances of that specific loan. And it is made on the basis or taking into account information that is specifically available in relation to that loan. A collective provision or a general provision is a provision calculated on the basis of an expected loss that will be incurred in respect of a loan, but also in respect of a body of loans with like tenors in like industries, with like risk grades, and is also based on a general deterioration in the loan book arising from economic circumstances prevailing at the time.
And so what this is explaining to us is that there's been an increase in the gross debt allowed for impaired assets, and there's also been specific provisions that have been raised against quite 13 times in terms of value the assets. I've put that very badly, but...
I think I understand, and I think the answer is yes.
And you think you agree. That's very comforting. And then one of the other issues in relation to risk is the concentration of the loan book in any particular issue. You agree with that?
Yes.
And if we go to the page ending .7475, we see in the second dash under the line points of interest from the CBA industry sector concentration policy review include, you'll see the acquisition of BankWest added a further $13.7 billion to the existing CBA commercial property concentration of $45.2 billion.
Yes.
Bringing the new CBA group total to $58.9 billion.
Yes.
So that the group concentration had risen from 8.5% to 9.9%.
Yes.
And that was against a limit of 10%.
That's correct.
And could you just explain to the Commissioner why a bank wants to have a limit on the concentration of its lending in any particular industry?
Yes, primarily because of the value of diversification across the portfolio of loans. The theory being that it was prudent to avoid excessive concentration in a particular industry sector in case that industry sector suffers a rapid or even gradual deterioration or decline.
And then I think I've already tendered that document, Commissioner, a few days ago. I thought I
have you?
might have tendered it yesterday when I was examining Mr. Perry, but I'm getting both a nod and a head shake from my instructing solicitor, so I'll tender it again. Not the same solicitor at the same time, I should say. That would have been very impressive.
Exhibit 3.113 will be submission to Risk Committee 25 March 09 CBA 0002 2076 7461.
And one of the I'm going to take you to another document which again isn't part of your statement, so I'll tell you what the document is. We'll see whether Dr. Higgins can just continue to magically produce them to me. It's CBA.0002.2092.4133. It's a strategy memorandum dated the 1st of April 2009.
Sorry, what date?
The 1st of April 2009.
Thank you.
Now, again, if you want to have a quick look through that document, Mr. Cohen, and then I'll ask you if that's one you've had a look at in the course of preparing to give evidence.
I believe it is. I believe I have seen it, yes.
And you'll see it's a document that's prepared by Mr. Sutton as the Managing Director of BankWest.
Yes.
Do you know how long Mr. Sutton had held that position as at the beginning of 2009?
My recollection is that Mr. Sutton was appointed as the Managing Director of BankWest shortly after CBA's acquisition on the 19th of December 2008.
All right. And then if we go to the page ending .4135, you'll see there's a heading, Reducing Risk.
Yes.
And then a paragraph 4.8, which is the quality of the BankWest business asset book is poorer than original expectations and we are actively de-risking the portfolio.
Yes.
And then in 4.9, we're also repositioning the business bank to reduce the high exposure to commercial property and lowering the maximum potential single name exposures.
Yes.
And that, as I understand it, is consistent with your understanding of one of the things that was being learned by CBA within the first few months of having acquired BankWest, which is that the quality of the loans were not as good as CBA had perhaps expected them to be.
In respect of business banking,
Yes.
that's correct. Yes.
The retail banking was a bit different.
Yes, that's right.
The retail banking seemed to be okay. It was just the business bank.
Correct.
All right. I tender that document, Commissioner.
Exhibit 3.114 will be Strategy Memorandum 1 April 2009, CBA 0002 2092 4133.
And then the next document that we'll go to is CBA.0002.2077.2173, which is a BankWest business portfolio review dated the 7th of April 2009. And if you look at the last page of that document, Mr. Cohen, you'll see that's prepared by Peter Deans, the Chief Risk Officer of BankWest. I'm sorry, the last page of the memorandum, which is
Yes.
.2175.
Yes.
So Mr. Deans held the position in BankWest at the time equivalent to the position that you now hold in CBA, is that right?
That's correct.
All right. And in terms of his responsibilities, which presumably reflect your responsibilities for CBA, what would they involve?
Broadly speaking, the Chief Risk Officer's responsibilities encompass leading the risk management team, which is responsible for identifying and managing risks across the bank.
And could you explain to the Commissioner two things? First, what's the type of process that you would go through in order to identify risks to the entity?
Well, the first step is to organise the risk management function into specialist teams. Specialist teams would deal with the different risk types, so credit risk, market risk, liquidity risk, operational risk, compliance risk, for example. Those teams would be comprised of specialists in those areas. Then those teams would normally be assigned to business units, such as the retail banking or the business banking or the institutional banking teams, and they would work closely with the business teams in those business units as those businesses undertake their day-to-day business. And they would advise the business team members on risks that were being taken. They would advise on how to mitigate those risks. They would they should challenge business unit team members on steps taken to mitigate risks. And they would also advise and challenge on the controls that a business has in place to manage those risks. And in some cases, the risk management teams would actually test those controls as well, or give a view, an assurance view, on the effectiveness of those controls.
And so would something like a concentration cap on a particular industry, would that be the type of control that you're talking about that might be implemented by the risk function?
Yes, so a risk function in its credit risk team, for example, one of those specialist teams that I mentioned, would have as one of its responsibilities to design policies to deal with credit risk. One of those policies would be a credit concentration policy, for example. Another might be an industry sector concentration. Another might be a geographic concentration, for example.
And this memorandum, is it one that you've reviewed in the course of preparing to give evidence, or you're not sure?
No, I am sure about this one because I received it at about 8:30 a.m. this morning, so it's more recent in my memory.
Oh, then that's perhaps convenient in some ways and not in others. Can we then have a look at the bottom of page .2173, which is the first page? So you'll see it starts with a summary of the type of review work that's being undertaken.
Yes.
And that's what you'd expect the risk function to carry out for a bank?
A risk function would carry it out or participate in the carrying out of it, yes.
And then you'll see there's then in section 3 some specific sector reviews that were underway at the time.
Yes.
And one of those was in relation to land bank exposures.
Yes.
And the other was in relation to hotels and clubs in New South Wales.
Yes. Yes.
And they seem to be two sectors that BankWest had been very active in making loans to.
Yes, so those the respective paragraphs say yes.
Yes.
And that's my understanding as well.
And then you see in 4.2 there's an explanation that the industry concentration cap for BankWest for property services was 50% and 15% for construction. In
Yes,
4.2.
yes, yes.
And what was being considered at that time was revising down the concentration caps.
That's correct, yes.
And you're aware that that's what occurred?
Yes, I am.
And in terms of prudent risk management, that's something that makes sense to you? You obviously weren't involved in it at the time, but looking back on it and your experience now as a Chief Risk Officer, that makes sense?
Yes, it does.
Given A, the high concentration of the total committed exposure for BankWest in particular industries,
Yes.
and B, the extent of the effect and potential effect of the global financial crisis?
Yes, those would be two reasons.
And are there other reasons that you'd identify as well?
Well, perhaps associated with the first reason that you identified is because of the high concentration in one area, the relative lack of diversification across the remainder of the sectors. So therefore leading to less of an ability to ride out difficulties in one sector because of the heavy concentration in that sector.
And I'll tender that document, Commissioner.
BankWest Business Portfolio Review, 7 April 2009, CBA 0002 2077 2173, Exhibit 3.115.
And then the next document is an Executive Risk Committee memo dated the 11th of September, a memo to the Executive Risk Committee for a meeting on the 11th of September 2009, CBA.0002.2081.8557. Now, is this a document that you've seen Mr. Cohen in the course of preparing to give evidence?
Yes, it is.
All right. And is this as I've just suggested, a memo to the Executive Risk Committee of the Commonwealth Bank
Yes, it is.
for what appears to have been a meeting to occur on the 11th of September 2009?
Yes.
And the memo is setting out certain proposals in relation to the commercial property section or commercial property loans of Commonwealth Bank.
Yes.
And then if we go to page .8558 and pop out paragraph 4.2, this is explaining what was proposed in relation to BankWest's investment in commercial property,
Yes.
which was to reduce its exposure and cap it through to the 31st of December 2010.
Yes.
And were you aware at the time of the introduction of these caps?
No, I don't recall it.
All right. But in looking back at it now, presumably this seems like a prudent response to the over-concentration in commercial property of BankWest?
I believe so, yes.
And I tender that document, Commissioner.
Memorandum to Executive Risk Committee, 11 September 09, CBA 0002 2081.8557, Exhibit 3.116.
Now then, this is September 2009. Once it gets into 2010, there continue to be concerns about the quality of the BankWest loan book. Is that fair?
That's correct, yes. The business loan book, yes.
The business loan book, I'm sorry. And if we bring up your statement at paragraph 122, sorry, that's if it assists CBA.9000.0045.0001 and the page is .0028. And it might actually be helpful to blow up paragraphs 121 and 122. one of the things that had happened during the course of 2009 was that the provisions being made for the BankWest loan book had been BankWest business loan book had been increasing. Is that right?
That's correct, yes.
And again, just so we're clear about this, the provisions is what BankWest is recording as the loss that it is expecting to make on a particular loan. Is that a
Broadly speaking, that's correct.
accurate
Yes.
summary? It's not concerned with whether or not the loans have actually been defaulted or
That's
not
correct.
at the time.
That's correct.
And the point you make at 121 is that, based on presumably your review of the documents and looking back through the corporate memory, there'd been this increasing concern on the part of CBA and BankWest about its collective provisioning models. That was one concern.
Yes, my statement is based on, as you say, looking back in the documents, but also my personal knowledge from the time.
I see. You can recall by early 2010 there was this issue that people were very conscious of.
That's
within
correct.
the bank.
Yes.
Right. And so one of the issues was about the effectiveness of BankWest's collective provisioning models
And their collective provision processes as well.
and the processes.
Yes.
And is it fair to say it appears as if there was a limited number of people within BankWest that had skills in relation to collective provisioning?
Not that I knew it at the time, but in preparing for today's appearance, yes, I've become aware that there were a limited number of people with sufficient provisioning skills.
Yes. And also that there were concerns both for CBA and BankWest about the extent to which the business loan portfolio was being managed. Was being monitored.
Yes, that's correct.
And then the final point you make is there was also a concern about whether the BankWest business loan portfolio was being credit rated and managed in accordance with the applicable equivalent CBA standards.
That's right.
Could you just explain to the Commissioner what you mean by that third point?
Yes. The concern was that potentially the credit ratings used by BankWest when it was rating particular business loans were perhaps not as diligently applied as Commonwealth Bank applied credit ratings. And secondly, that the ongoing management, that is the day-to-day management of a loan by the business relationship managers, was not as active and the loan and the progress of the loan through its life cycle was not as actively monitored by the relationship managers as it should have been.
And the risk rating that's given to a particular loan has an effect on, amongst other things, whether it's considered to be troublesome or impaired.
That's correct. Yes.
And also has effect on the pricing that needs to be applied to the loan, having regard to the risk involved.
It can have that effect, yes.
And are there other matters of significance that arise from the risk rating, apart from the two we've just mentioned?
I think certainly the ongoing management of a loan during its life cycle is influenced particularly by the risk rating as well.
But I think you told me that risk rating affected collective provisioning.
Risk rating is a factor in collective provisioning as well, yes, Commissioner.
Yes.
And it was this concern that led to what's referred to as Project Magellan?
That's correct. Primarily a concern about whether collective provisioning was being adequately undertaken.
And there were, it appears from the documents we've reviewed, a few different projects that were put in place by BankWest, but effectively CBA into BankWest in order to deal with different aspects of the risks and concerns?
There were a number of reviews undertaken by BankWest.
What I'd like to, just so that the Commissioner can understand, is there are a number of reviews that have been undertaken, and I'll come to a couple of those in relation to, for example, property finance. You're presumably familiar with that.
Yes.
And we'll come to that. But in addition to, say, Project Magellan, there was a Project Columbus, is that right?
That's correct. That's correct.
And there was, I think, at least one other one also named after an explorer although I can't remember the name of the Explorer now, but also designed to address some aspect of the risk and management within BankWest. Can you recall that?
The only two Explorers that I'm aware of that had projects named after them were Magellan and Columbus.
All right, we'll come to Magellan in more detail, but could you just explain to the Commissioner what Project Columbus was?
Yes, Project Columbus was primarily a project to add additional resources and improve the operating procedures of the credit asset management team within BankWest. The credit asset management team is the team that specialised in looking after troublesome and impaired loans.
It's the equivalent of what is now the GCS within
That's correct.
CBA, is that right?
That's correct.
And in 2012, CAM from BankWest was effectively merged into CBA's GCS team, is that right?
That's correct. Yes.
Now, before Project Magellan, which happened in about April and May of 2010, or at least started really getting going.
Yes, it commenced its planning commenced in February 2010 and it concluded approximately early June 2010.
And one of the reviews that was underway, we might be able to see by having a look at a document which is CBA.002.1564.1319, which is a presentation from March of 2010. Is that a presentation you've had the opportunity to look at in preparing to give evidence?
Yes, I have.
All right. So this appears to be an internal presentation of BankWest.
Yes, it does.
And if we go over the page to .1320, it's providing a summary of the introduction of a watch list process.
Yes.
Could you just explain to the Commissioner what a watch list is?
Yes, a watch list is a list of loans where the credit rating of the loan has not yet got to the stage of being classified as a troublesome or impaired asset, but the credit health of the loan has started to deteriorate and is causing a level of concern, but not to the point where it becomes a troublesome or impaired asset.
And is one of the reasons why you would want to have, or a bank would want to have a watch list in place in order to identify and manage loans before they reach the point of becoming troublesome or impaired and being passed over to CAM?
Yes, it is, because the intent would be to try and prevent a loan reaching a level of downgrade in credit rating such that it became a troublesome or impaired loan.
And it appears as if BankWest didn't actually have a comprehensive watch list process in place at the time that it was acquired by CBA?
That's what I have taken from the first box there on the right-hand side of the document.
And that wasn't implemented until April and May of 2009?
Yes.
And then you'll see if we come over the page to .1321, that in the box in the right-hand corner, over the period from July 09 to February 2010, 250 new groups with a value of $1.4 billion were transferred into CAM.
Yes.
And that would mean they had been identified as being troublesome or impaired.
That's correct.
And there was, as explained in the second box, a net CAM portfolio increase of $0.7 billion.
Yes.
Which would mean, logically, that was because quite a number of groups or borrowers already within CAM had either been repatriated back to business units or had been exited in some fashion from the business.
That's correct. Yes.
And when we use those terms, repatriated and exit, CAM's goal, is it fair to say, is to manage the loans to the point where they are no longer in CAM?
Yes, that's correct. Either through rehabilitating a loan so that it is what we would call a pass grade again, so that is it's a better credit grade than a troublesome or impaired level, or work with the customer to end the relationship in a normal way, such as when a loan matures, when it reaches expiry, or through repayment via refinancing, for example, or if none of those were available, then through enforcing as a last resort.
And when we use the term repatriated, that is the situation where the loan has been rehabilitated and has passed back to a business unit for management by the ordinary business unit.
That's correct.
And the rehabilitation, or an important part of the rehabilitation, is to reduce the risk grade of the loan so it's no longer troublesome or impaired.
That's correct, yes.
And then the point made in the third box on that page is that of those $1.4 billion transferred over, $1.2 billion had been on the watch list.
Yes.
And this increase of loans becoming troublesome or impaired, that was consistent with, or what's set out here as to that increase in loans becoming troublesome or impaired is consistent with what you understand now as to what was happening with the BankWest business at the time?
It is consistent with what I understand now.
And also with what you understood at the time?
Certainly at the time, in 2009, my understanding was that, and as I've alluded to in my statement, there were a number of unexpected provisions being made for business loans. And so, yes, at the time I understood that those provisions were increasing.
Attend to that document, Commissioner.
Presentation March 2010, watch list, troublesome and impaired account update, CBA 0002 1564 1319, Exhibit 3.117.
And then the next document is CBA.0002.1564.4782. And this is a set of emails between some people within BankWest, I think, and there should be I'll just indicate there should also be an attachment which we'll come to in a moment, but I'll just give the identifying doc number. It's CBA.0002.1564.4784. We don't need to bring that up yet, but this is an internal email from the 17th of March 2010. You see that at the top of the page?
Yes.
And again, is this a document you've reviewed in the course of preparing to give evidence?
Yes, I received this document and the attachment this morning as well.
All right. And the email is from the Managing Director of BankWest to Mr. Blair at CBA?
Yes.
And what was Mr. Blair's role?
Mr. Blair was the group executive responsible for the International Financial Services business unit of CBA, and despite the name of his business unit, had responsibility for the BankWest business.
Okay. And this is an email that describes some things that followed a review of the property finance unit?
Yes.
The property finance unit was a unit of BankWest that made loans of where the borrower group was borrowing, was it more than $5 million for property finance?
I believe so, yes.
And Mr. Sutton's summary of it is the credit review of the property finance unit makes for very poor reading and highlights a few things. One was that there was no real credit review process in place, and he had asked for the team to be strengthened.
Yes.
And he says this is a third line of defence. Can I just pause on that? Was BankWest implementing a 3 lines of defence model in its risk management?
If I could just clarify one point, the 3 lines of defence model is not a model that applies just within risk management. It's a model that applies across the whole of a business. The first line of defence is the business itself, so in the business line. The second line of defence is the risk management function, and the third line of defence is the internal audit function and the external auditors.
Yes. And so in this case, he's talking about strengthening that third line of defence.
Yes, that's correct.
All right. And presumably that indicates in some fashion, though perhaps not a very good fashion, BankWest had been implementing something like a 3 lines of defence model.
Yes, it suggests that that third line of defence needed to be stronger.
And that reflects your understanding of one of the concerns that CBA had by 2010, which was the inadequacy of risk management at BankWest? Not necessarily after CBA had acquired it, but before CBA had acquired it.
No, my understanding today, as a result of reviewing the documents for my appearance today, is that while there were concerns about some aspects of the risk management function, there were also concerns about the operation of the business itself when it was assessing credit. So it was both at the business level and at the risk management function level.
Yes, and then perhaps is the first point at the business level, is that what's then being called out in that next paragraph, which is this confirms what has been called out in the past about previous management and strategy on the East Coast?
I believe so, yes.
And is it fair to say that one of the issues that was identified by CBA after it acquired BankWest was that BankWest had adopted a very aggressive strategy in lending on the East Coast in relation to business, I should?
Yes, and if I could be a little bit more specific, specifically in relation to commercial property as well.
And
Sorry, especially with respect to commercial property Australia-wide, or especially with respect to commercial property on the East Coast?
Australia-wide, but exacerbated on the East Coast.
Thank you.
And if we go to the attachment, which is CBA.0002.1564.4784, and can we blow up the second and third paragraphs under credit quality? This reflects the points you're making, Mr. Cohen.
Yes, largely with a focus on New South Wales and Victoria. Yes.
That's the eastern states problem that BankWest seem to have.
That's correct.
Right. I tender those 2 documents, Commissioner.
The email from Sutton to Blair of 17 March 2010, CBA 0002-1564-4782, and the attachment, Property Finance Unit National Survey Credit Review, CBA 0002-1564-4784, together become Exhibit 3.118.
And then the next documents I want to show you, Mr. Cohen, are an email of the 17th of May 2010, which is CBA.0002.1533.1262, and an attachment which is CBA.0002.1533.1265. Do you have just the email or do you have the attachment as well?
No, I have the attachment.
Your attachment looks different to mine, which is concerning, but we'll see as we get to it. The first document we're looking at is an email that's sent internally by one BankWest employee to other BankWest employees.
Yes.
And you've reviewed this email and the attachment for the purposes of giving evidence today.
Yes, I have.
And the email, I thank you, now you've got the attachment. The email is setting out what is described as the executive summary of overall project reviews for BankWest Business with a breakdown for Project Magellan.
Yes.
And if we then go to the attachment, which is the PowerPoint slide, CBA.0002.1533.1265. This is setting out the extent of existing reviews and the proposed review by Project Magellan of the BankWest business book.
Yes, I believe so.
And you'll see in the top left corner, it explains that 61.2% of BankWest business will have been reviewed by the time Magellan is completed.
Yes.
And does that reflect your understanding of the extent of the reviews that were undertaken of the BankWest business book?
It's my understanding since my review of the documents for preparation for today, yes.
Right.
Although there are various percentages that float around in different documents, but
depending on how you calculate
yes,
it and which
exactly.
particular figure you use. But broadly, more than half of the BankWest business book ended up being reviewed across various reviews.
Yes.
And as we'll see, those reviews identified what had already been suspected and was of concern, which was that there was inadequate provisioning that had been made by BankWest.
Yes, I can't speak to each of the reviews specifically. I can, of course, speak more specifically about the Project Magellan outcomes. But broadly speaking, each of the reviews uncovered some concerns around the level of provisioning.
Attend to those documents, Commissioner.
Email 17 May 2010, Armistead to Pike and others, CBA 000215331262, and attached presentation concerning Project Magellan, CBA 000215331265, together Exhibit 3.119.
Now, the Project Magellan review was a review of what's been described in inverted commas as the good book from
Sorry, was the described as?
the good book from BankWest's business portfolio, is that right?
Yes.
And because this term can perhaps lead to some understanding, can we be clear about what that means? That means the book that had not been classified as troublesome or impaired at the time that the review was undertaken.
That's correct.
And so what caused or was the genesis for BankWest was a concern about whether the classification of all of those loans as part of the good book, that is not troublesome or impaired, was accurate?
That's correct, with the only qualification to that being that the focus was on whether the classification was accurate and therefore, most importantly, whether that led to a shortfall in collective provisioning.
And so what was sought to be done was to review these files, quite a lot of files, in order to,
Yes.
that were part of this good book, in order to determine whether there had been proper rating of the files. That's the first part of it.
Yes.
And then the second part of it was to then determine whether there should be an adjustment to the amount of collective provision that should be made in respect of what was described as the good book.
Yes, that's correct, for two reasons,
Yes.
if I can explain those.
Yes.
One was because of a prudential obligation to accurately provision, and the second was in order to include in the financial statements for the period ending 30 June 2010 the accurate provisions so that the loan impairment expense could be accurately calculated and then deducted from retained earnings so that the profit for the period ending 30 June 2010 could be accurately stated, particularly for market purposes.
And I want to attempt to summarise the way in which Project Magellan was approached. The first way was that there were certain criteria set in order to identify what files were going to be reviewed. Is that right?
That's correct, as set out in my paragraph 125.
And so, for example, it was decided to review all hotels and pubs,
That's correct.
and then also to review anything with a security valuation over $5 million where the revaluation was more than 2 years old,
That's correct.
and various other criteria that were used, for example, about aged care and overdue annual reviews, things like that.
That's correct.
And then once those criteria had been applied, there were then independent reviewers brought in to review files.
Independent, as I've described in my statement, namely independent of the business relationship managers.
Yes, and perhaps we should just be clear about what that means. The business relationship manager in relation to a loan within the good book might be a relationship manager who sits within property finance,
Yes.
for example, or a relationship manager who sits within the commercial business unit.
Yes, that's right.
And that relationship manager would have the task of managing the relationship with a certain number of borrowers in a certain region, typically.
That's correct.
And so the idea was to review these files independent of that relationship manager who's supposed to be having the day-to-day dealing with
That's
the
correct.
borrower.
That's correct.
And there were involvements of some external accountants in the carrying out of the reviews.
That's correct.
And, for example, Ferrier Hodgson, I think, were appointed to review one particular set of types of loans.
That's right. Yes.
And just to help us to understand this point about independence, I had understood, perhaps mistakenly, that it was somebody like an accountant from Ferrier Hodgson who was being referred to as the independent reviewer. Is that not quite accurate?
No, not quite.
All right.
No.
Could you just explain that to us then?
Yes. So the team that carried out the review was a team of some, I'll just find the exact number for you. Yes, in paragraph 139B of my statement, approximately 42 business credit specialists. So these were people from the business credit team within the risk management function, including some CBA people, as well as people from external firms, formed the 42 people who carried out what I described here in 139B as step 2 of the review process. So it was a combination of internal people and external people who were seconded in to assist.
Right. And so they would, again, just so we make sure there's no confusion, it doesn't mean that there was a step where somebody independent of the relationship manager within BankWest would review it, then it would be reviewed by an independent accountant, then it would be reviewed by the panel. It just means that in some cases, the independent review would be carried out by the accountant from an external firm. In some cases, it would be carried out by somebody else with credit experience, independent of the relationship manager.
That's exactly right.
And then once that review and report was completed, that would then be passed up to a panel.
That's right. There was a review panel, which was effectively 2 panels.
And, sorry, when you say there was effectively 2 panels, what do you mean by that?
Yeah, sorry. Just to explain, there was a review panel, which was the 3rd step described in 139C of my statement. It was actually 2 panels, 2 separate panels, but together they formed the review panel for the 3rd step of the review process.
All right. And they could either accept or reject or modify the recommendations that have been made by the independent reviewer.
That's correct.
And then,
And
As
were
a-
the panel members internals or externals or both?
They were, from memory, Commissioner, they were all internals. They were generally senior people within the business and the risk management teams.
and once that review had been undertaken, one of the things that would be finalised was the risk grade that was allocated to the particular borrower coming out of the panel's finalised recommendation.
That's correct.
And that was one of the things then that would be taken into account in determining whether adequate collective provision had been made.
That's right, yes.
And so what the business, that is the BankWest business, was trying to get done by the 30th of June was to make sure that it had, as best it could, made adequate collective provision in relation to these loans.
That's correct.
And as far as it could, it did that.
Yes, as far as I know, yes.
And that is a separate issue from the management of the files after that part of Project Magellan was completed.
That's correct.
And what then would happen is that some files, based on the recommendations that were made by the panel, might be transferred over to CAM.
That's correct.
And can we bring up your supplementary statement? You've, not personally obviously, but you've asked people within CBA to conduct an analysis of the files that went into CAM coming out of the Project Magellan reviews.
That's correct.
And of the recommendations that came out of Project Magellan, there were 161 files that were transferred into CAM.
Yes.
And if we bring up paragraph 9, which is on page .0002, and also the table on the following page, can we bring both of them up on the same screen? What the analysis shows is that of the 161, there were 31 that over the course of the next 7 years ended up being rehabilitated and returned to the business unit.
That's correct.
There were 37 that were terminated by enforcement action.
That's correct.
And just to pause on that, just in the first financial year, FY11, after Project Magellan, it was 17 that were rehabilitated or returned back to the business, what's
Yes.
referred to as repatriation in some documents.
Yes.
And 15 that were terminated by enforcement action.
Yes.
And then of the remaining, you've said of the remaining 124,
Yes.
I'm not sure the maths quite works on that. Is there a, if there were 161 files transferred into CAM
Minus 37?
minus,
So
oh, I'm sorry,
the
it's
120,
31.
sorry.
Yeah, no,
Sorry.
go on.
No, I was just going to say the 124 is arrived at by taking the 161 that were transferred in first, and then deducting from that the 37 that were terminated through enforcement action.
All right. And so of the 31 referred to as continuing on the same terms means 31 that were transferred, rehabilitated back into the business units, is that right?
No, they're not necessarily the same 31,
I see.
unfortunately. It's a coincidence.
All right. So of the 124 left, does that mean they weren't necessarily transferred back to the business unit?
That's correct. Of those 124, over the period of time, the 124 either continued and then just met their normal expiry. Some may have ended early through refinancing. Some may have ended early through repayment before expiry.
Commissioner, is that a convenient time?
Yes, how long do you think we'll require for Mr Cohen? I just have in mind how the program's going,
I think
Mr Hodge.
perhaps an hour and a half to 2 hours in the morning.
Yes.
Of course, I should point out that Mr Donnelly constantly tells me that you need to add 50% to any estimate of time that I give.
He's a
I
very
don't think
cautious man, Mr Donnelly, is all I'll say. The usual multiplier when I was a judge was double it, Mr Hodge, I hate to tell you. We won't do that this time. But I'm afraid we'll have to ask you to return at 9:45 tomorrow morning, Mr Cohen.
Certainly.
We'll adjourn until that time. Yes, Mr Hodge.
Commissioner, we're continuing with the evidence of Mr Cohen.
Yes. Mr Cohen in court, yes. Thank you, Mr Cohen. I should get out of the habit of saying, is Mr Cohen in court, shouldn't I? He's not. Yes, Mr Hodge.
Thank you, Commissioner. Mr Cohen, there's just a few more documents that I want to take you to concerning Project Magellan. The first is document CBA.0002.1566.7527. It should be Exhibit DC-69 to your statement.
Yes, I have it.
Thank you. And that will hopefully come up on the screen in a moment. This is a report to BankWest's audit committee by PricewaterhouseCoopers.
That's correct.
And if you go to the second page, which is .7528, you can see it's for the year ending 30 June 2010 and completed by about the end of July 2010. See, it's dated 29 July 2010.
Yes.
And you've obviously reviewed this document for the purposes of preparing your evidence.
That's correct.
Do you want to just explain to the Commission what it was that PricewaterhouseCoopers was asked to do?
Yes. In the context of preparing the financial statements for BankWest for the period ended 30 June 2010, PricewaterhouseCoopers specifically looked at the process and the outcomes of Project Magellan. And I understand they did that so as to satisfy themselves that the contribution made by Project Magellan to the calculation of collective provisions for the purposes of inclusion in the 30 June 2010 financial statements were correct or accurate or had been undertaken in an appropriate way.
And can I just identify a few parts to that? So the first thing is the role of PricewaterhouseCoopers was obviously to audit the financial accounts for the year ending 30 June 2010.
Yes, that's correct.
One of the things they needed to satisfy themselves of is effectively the accuracy of the information that they're provided with in relation to those accounts.
Yes.
And one part of the accounts is the provisioning that's made for losses that might be made on loans that BankWest then had outstanding.
Yes, in the sense that an element of the financial statements are loan impairment expenses, and loan impairment expenses are in part made up by collective provisions.
If we go to page .7531, this is a section of the audit report where PricewaterhouseCoopers deals specifically with the credit provisioning that had been made.
Yes.
And the opinion of PricewaterhouseCoopers was that a prudent approach had been used in calculating loan loss provisions.
That's correct.
And you see under 2.1, PwC identifies that the total provisions had increased from $1.28 billion to almost $2.1 billion over the financial year.
Yes.
And then there's a reference there to this being largely the outcome of Project Magellan and the continued deterioration in the business portfolio. We then turn over the page to 2.2, which is, thank you, .7532. PwC specifically considered Project Magellan and reviewed or conducted a review of Project Magellan.
Yes.
And then if we then go to the document which is DC-71 to your statement, which is CBA.0517.0091.0500. This is a draft, but a draft of a presentation seemingly for the board on the date of the 15th of July 2010 dealing with the outcomes of Project Magellan.
Yes. Yes.
And if we go to the page .0501, there's a summary of findings which sets out a number of the difficulties that have been identified in both the credit provisioning but also the management of loans within BankWest.
Yes.
And I just want to, for the benefit of the Commissioner, note a few specific points. You see there's I'll say the fifth bullet point on the page. Prior to this, that is prior to the additional collective provisioning, there is evidence both business line management and business credit held an overly optimistic assessment of ongoing customer viability on certain exposures.
Yes.
And that was one of the issues that was identified by mid-2010, which was there had previously been a level of perhaps unjustified optimism on the part of BankWest in managing its exposures.
Yes.
And then there's then an explanation that as a result of Project Magellan, there's a 15 to 20% reduction in security valuations across the portfolio.
Yes.
And that specifically reflects the poor quality security for loans on the East Coast.
Yes.
And we discussed that yesterday about the issues with the East Coast part of the book.
Yes.
And then if we go over the page to .0502, there's an identification of another specific issue in relation that gave rise to that problem, which was that independent valuations have been relied on to support business, but that's underwritten at or near the top of the cycle. So that is 2006 to 2008.
That's correct.
And that was a particular problem, as it turned out, with the BankWest loan book, which was that there were a lot of business loans made on the East Coast in the lead up to the GFC when the market was at its peak.
Yes, amongst other problems.
And then there's a further issue that's identified, which I just want to call out a little further down the page, which is the third last bullet point. There was evidence of a failure to take decisive action on early warning signs such as covenant breaches and earnings shortfalls against expectations to instruct independent review and/or revaluation of assets. I'm just wondering if you might be able to explain your understanding of that point to the Commissioner.
Yes, my understanding is, as alluded to in evidence I gave yesterday, the ongoing management of loans during their life cycle, in other words, prior to reaching TIA status, had been lacking. And I believe this third last dot point on that page is referring to the fact that the lack of active, ongoing monitoring of a loan had led to a failure to take action when early warning signs arose. Those early warning signs being, as suggested in that last dot point, where there had been covenant breaches, and I believe that's a reference to financial ratio covenant breaches.
And there's a couple of different types, or a few different types of financial ratio covenants, but would that include an LVR ratio covenant?
It would include that amongst others, yes.
And would also include an ICR covenant?
That's correct.
And the DSR covenant?
DSR covenant, that's correct.
And then the last bullet point on the page is wholesale approach to improve risk culture commenced under Sonic program with immediate direct action to strengthen control framework and revamp policies, practices, training and compliance. Do you know what the Sonic program was?
Yes, I do, and I'm happy to explain it.
Yes, could you explain that to the Commissioner?
Certainly. Project Sonic was the implementation of a new strategy by BankWest Business Bank. That new strategy was known as straightforward banking, and it was in effect a return to the basics of business banking by BankWest Business Banking. Project Sonic involved the implementation of that strategy, which incorporated, amongst other things, training of business bankers, a change of risk appetite in relation to the types of business loans that BankWest Business would write, monitoring systems, ongoing measurement of things like ratios in order to improve the performance. It also included changes in the types of loans and the amounts of loans and the tenor of loans. So it was quite a wholesale change of strategy, and Project Sonic was the implementation of that strategy.
And was any part of that to try to bring the approach of CBA to risk management into BankWest?
Project Sonic was focused largely on the business bank section of BankWest, namely the business itself rather than risk management, but there were parts of Project Sonic in which the risk management team of BankWest were involved and which required changes in the way that the risk management team of BankWest interacted with the BankWest Business Banking Division.
All right. Can we go to the page .0508, which is page 9 down the bottom? So this is setting out, or attempting to summarise graphically and with key messages what has happened in relation to the balance sheet provisions as at the 30th of June 2010.
That's correct.
And we can see there, consistent with what we've been speaking about now for some time, this increase in the troublesome and impaired assets.
Yes.
And the key point reflective of all of the documents that we've seen thus far, or the first key message is provisions more than double worst performing peer, more than 4 times the average of the big 4.
Yes.
And in some ways it's fair to say that sort of gets to the heart of the issue with the BankWest business book, which was that it was, in terms of the level of provision, well outside the range of what was consistent with both peers and also with the Commonwealth Bank.
It was well outside that range, yes.
And then if we go over to page .0510, this then sets out what's described as the key learnings identified during the Magellan review.
Yes.
And again, I think these are all consistent with things we've discussed with, but I'll highlight them for the Commissioner. First, that there had been this aggressive risk appetite during 2006 to 2008 for BankWest.
Yes, that's correct.
Second, that there was poor quality business written on the East Coast and this lack of ongoing management, which you've spoken about a number of times.
Yes.
Third, that there was a significant deterioration in security valuations.
Yes.
And then there's a couple of other points on page .0511, but can I skip that and go to 0512? And highlight this specific issue about property lending, which is that this was a particular part of the business portfolio which was problematic for BankWest, the property lending.
Yes.
And as we saw from various documents, it had, by mid-2009, it had risen to being over 50% of the BankWest business book. The
Commercial property, yes.
Commercial property.
Yes.
And one of the problems then that arose and was continuing to arise by 2010 was the substantial decline in the value of the assets that were securing those loans.
That's correct.
And hence, the short-term action that we see there is the implementation of a property lending cap.
That's correct.
And then, can we jump forward to 2013 and bring up CBA.0001.0359.0781.
Thank you.
I think this will come up in a moment, but this is you've got the hard copy in front of you, Mr.
I do,
Cohen.
thank you.
And this is a report to the Commonwealth Bank's Executive Risk Committee dated the 5th of March 2013.
Yes.
And I think you've seen this document overnight.
I have, thank you.
And if we go to, I'm sorry, I might give the, there we go. This is giving a report to the Executive Risk Committee on where BankWest commercial property was at.
Yes.
And if we go to the page, which is .0784, we can see what's now happened to commercial property for BankWest over the course of the preceding few years.
Yes.
And it's dropped off from a peak as at July 2009 of $14.79 billion down to, by the end of 2012, just under $10 billion.
Yes.
But held steady at that level of about $10 billion since around January of 2011.
Yes.
And it may be helpful if you're able to explain, Mr. Cohen, does exposures reflect the level of loans still on the book taking into account provisions or not taking into account provisions?
The exposures are the same regardless of what provisions are taken. So this graph represents exposures that were existing throughout, inclusive of, well, sorry, when I say inclusive, I should say the exposures remain constant. Whatever provisions might occur would rise or fall, as the case may be, but the exposure that the bank held towards commercial property was as depicted here.
Thank you. Commissioner, I attend to that document.
Report to CBA Executive Risk Committee, 5 March 13, CBA 0001 0359 0781, Exhibit 3.120.
Mr. Cohen, I want to now move to another topic, which is to deal with the evidence of Mr. Stanford.
Yes.
You've been put forward by the Commonwealth Bank as the witness to respond to Mr. Stanford's evidence.
Yes.
And in the course of preparing to give evidence, you've reviewed documents held by the Commonwealth Bank in relation to Mr. Stanford.
Yes, I have.
And if we just run through some basic things to begin with, you know that the original facility that was granted to or provided to the Stanford brothers was entered into in 2006.
Yes.
And the amount of that original facility seems to have been $1.2 million.
Yes.
And the purpose of the loan was to assist Mr. Stanford and his brother to purchase the Coronation Hotel at Portland.
Yes.
And in support of their application for a loan, the Stanford brothers provided a valuation report prepared by one of BankWest's panel valuers.
Yes, that's right.
And the report valued it at $1.6 million in 2006.
That's right.
And before the facility was approved, there was a credit risk submission prepared by BankWest.
Yes, that's correct.
And can we bring up CBA.0001.0285.0944, which is Exhibit DC83? This is that credit risk assessment.
Yes.
And you see the risk grade in the top quarter of the page is 5.
Yes.
And you've given some evidence in your statement about what the credit risk grade system was that was employed by BankWest.
Yes.
And under that system, BankWest was using a scale of 1 to 10 to grade its risks.
That's correct.
And a risk grade of 5 meant that the loan was considered performing.
Yes.
Unsurprisingly, given that you were making the loan at, or BankWest was making the loan at
It was in the
that
middle
time.
of the range.
And what that meant was it had, when you say it's in the middle of the range, it had some risk of default, but not a high risk of default.
It was an acceptable risk of default, so the probability of default, as reflected in that risk grade, was medium.
And then if we go over to page .0950, we see under the risk assessment heading, there's a section which is security, and the LVR is said to be 75% in line with lending policy guideline.
Yes.
And do you know, did the lending policy guideline for LVRs for pubs change at BankWest at some point in time? That is, was 75% always acceptable, or did it later become unacceptable?
To my understanding, there was a change at BankWest. I can't tell you exactly when that was, but depending on the type of property loan that was undertaken, it reduced from 75% to a lower percentage.
All right. And then, can I just ask you one thing which you may not be able to help us with? Can we go to page .0949? Can we blow up that, the last line, which is DSR? So that's debt service ratio, is that right?
That's correct.
And this is just a point of curiosity, it won't take us anywhere, but do you know how it is that you can have a debt service ratio of 1.68 for 2004, sorry, 1.64 for 2005, 1.65 for 2006, and an average of 2? I'm just wondering if there's something we're missing in the calculation of that. It's not a criticism of the bank.
No, I don't.
No, okay. And then can we go then to Exhibit DC81? So this is the letter of offer that was sent by BankWest to the Stanfords.
That's correct.
And if we go to page .5117, this was what's described as a fully amortising principal and interest loan.
Yes.
And that means the principal would be paid off over the life of the loan.
That's correct.
And the amount of the loan is $1.2 million, we can see.
Yes.
And the expiry date is 20 years.
Yes.
So the expectation for the loan is that it will be paid off over the course of 20 years.
That's correct.
And if we go to 6.3 on page 5120, you see so just before we go to that, if we look at 5.2, we see what the securities are that are given for the loan. So the first is a mortgage that's going to be given over the property that's to be purchased by the Stanford brothers.
Yes.
And then there's a fixed and floating charge to be given by Let It Rain.
Yes.
And Let It Rain, as we understand it, was the entity that was actually going to run the business.
That's my understanding too, yes.
And then there's also a mortgage that is to be given over a New South Wales mortgage over the business,
Yes.
which is a charge over the liquor licence.
Yes.
And you see then clause 6.3 is, we may require that any secured real property or any of your other assets or those of a guarantor be revalued every 3 years or at more frequent intervals determined by us by a valuer appointed and instructed by us at your expense.
Yes.
That was a standard clause, was it, in BankWest loan documents at the time?
Yes, as I understand it.
And in a case like this, what would be the expected purpose if the loan is to be repaid over the course of 20 years, revaluing the asset every 3 years?
So when a loan is written, a number of factors are taken into account in the assessment of whether to make the loan or not. One of those factors is the value of the security being offered. In this case, it was primarily the mortgage over the hotel. The pricing and the view of whether or not the loan was a loan that should be made is influenced to a large degree by the value of that security. The purpose of the clause 6.3 was to enable the bank to get an updated view of the value of the security in order that it could determine whether the pricing for the risk that the bank was taking in making that loan continued to be appropriate, firstly. And secondly, whether the value of the security continued to be sufficient to enable the bank to consider that its prospects of recovering the loan in the event that the borrower failed to make repayments would continue to be sufficient.
And as to the second point, what would be the consequence if the bank formed the view that the value wasn't sufficient to cover what it had loaned out if the borrower stopped making repayments?
So if I can address that at a general level rather than
Yep.
this specific case. At a general level, the consequence would normally be a discussion with the borrower to ascertain how the bank and the borrower might work together in order to come to an arrangement that would enable the bank to feel that it was still sufficiently covered in the event that the borrower failed to repay as scheduled. Those arrangements might include, for example, the borrower paying down the debt owed to a greater degree than it has been. So, for example, increasing the amortisation of the loan beyond what was originally scheduled. Or it could mean that the additional security might be offered by the borrower to enable the bank to feel that its coverage of the debt was then sufficient. Or it could be that some assets might be sold, perhaps some assets associated with the loan might be sold in order to be applied to repayment, again to leave the bank in a position where it felt that its ability to be repaid the loan was sufficient in the event that the borrower failed to make repayments as scheduled.
So a purpose of getting the revaluation done every 3 years, even where the loan is for 20 years, is so that the bank can identify a risk to itself that it might not be able to recover fully in the event that there was a default in payment.
That is one of the purposes, yes.
And then to take steps to attempt to mitigate that risk in advance.
Yes, particularly if the valuation was to show that the borrower was experiencing some financial difficulties, and valuations can quite often be strong indicators of that.
And the first point you made was about pricing for risk.
Yes.
When the bank decides on the interest rate that it will charge to a borrower, it takes into account the risk of the particular loan that it's writing.
That's correct.
And so when in this case the loan was written, the particular margin that was to be applied to BBSY would take into account the risk grade that the borrower was classified within.
That's correct.
And so in this case, if we go back to page .5117, we see the interest rate was to be bank bill rate plus a margin of 1.18% per annum or fixed rate.
Yes.
And if we leave aside the fixed rate for a moment, in the event that in 3 years' time the loan was regraded as a risk grade 6, would you expect then that there would be a change that the bank would make to the margin that it was applying to the BBSY?
Not necessarily just because of a change to a risk grade of 6. That per se would not automatically drive a change. It may, depending on other circumstances relating to the particular borrower, but per se not of itself.
And the contractual basis for making that change, is that something that's contained within the general conditions or terms that apply to the loan?
I understand, sir.
All right. And is it a general clause that permits the bank to vary any clause or provision, including the interest rate, or is it something specific? Do you know?
No, I believe it's in reliance on a more general clause.
All right. And then if we go over the page to .5121, so these are the financial undertakings that are given in respect of this loan.
Yes.
And one of them is an interest cover ratio.
Yes.
And that means the EBITDA for the business needs to be at least 2 times the interest expense.
Yes.
And the other is a debt service ratio.
Yes.
And CAFDS, what does that stand for?
Essentially, that's the net operating income.
And that has to be at least 1.5 times the total debt service.
That's correct.
Now, there's no LVR financial undertaking in relation to this loan?
No, there is not.
And is there any observation you want to make about whether that's unusual or not unusual in relation to this type of loan?
I would say that probably more often than not, this type of loan would have had an LVR to it. It's not highly unusual, however, that it does not. I think in the context of a a going concern business, namely the operation of a hotel. Whilst the LVR is relevant and banks will always look at it, nevertheless, in the context of a going concern business, what's very important is to understand the EBITDA or the earnings of the business. And hence an ICR and a debt service ratio are two very important ratios.
I think I understand what you're saying. Can I'll make an observation to you, and then we'll see if we're agreeing with each other. For a business like this, the value of the business will largely, though not solely, depend upon a capitalisation of the maintainable earnings. Do you
That's
agree
correct.
with that?
Yes, I do.
And so as the earnings of the business drop, the value of the enterprise, if it was to be sold, drops.
That's correct.
And therefore, it's a bit different from just saying there's a piece of real property here, like a block of land with a house built on it, or vacant land, where you're not concerned with maintainable earnings. You're just concerned with what is the value of that property if it was put on the open market, depending upon the inherent value of that piece of property.
Yes, those two are different.
And so these financial undertakings, which link back to the earnings of the business, ultimately reflect in some fashion the total value of the business if it was to be sold.
That's correct.
And then if I just ask one other thing about the split of this loan, do you understand that at some point in time this loan was split into a fixed interest and variable interest loan?
Yes, I do.
And
Yes.
do you have an understanding of when that happened?
Actually, my understanding was better informed as a result of Mr. Stanford's evidence yesterday. I didn't know the exact period. I think Mr. Stanford said he seemed to recall it happening in 2007.
Yes. All right. So you, at some point in time, in any event, the loan was seemingly early in the life of the loan, it was split into a variable interest component and a fixed interest component.
Yes, that's right. And my understanding is that was pursuant to clause 3.3 of the loan agreement.
And that the particular point you're making is that the way in which it's split is to use a hedging facility as part of having the fixed interest. Is that right?
Yes, that's right. My understanding is that the interest rate swap, as it was called, was implemented, which fixed the interest rate for a portion of the total loan of 1.2 million.
Right. Now, I want to then go forward in time. You know that in March of 2010, BankWest received a request from the Stanfords for an overdraft facility.
Yes.
And it seems as if that request may have originally been made in 2009 and then repeated again in 2010, or you're not aware of that?
I'm not particularly aware of the 2009 request, no.
Right. But in any event, you know that in 2010, there was this request for a $20,000 overdraft.
Yes.
And the overdraft was to be attached to the BankWest business bonus account that Let It Rain was operating.
Yes.
And BankWest approved the $20,000 overdraft in April of 2010.
Yes, it did.
And in the period prior to approving the overdraft, BankWest had completed a number of regular credit risk assessments in relation to the Stanford's loan account and Let It Rain's business account.
Yes, it had.
And you've referred to some of those credit risk assessments in paragraph 168 of your statement.
That's correct.
And the credit risk assessments were completed by a relationship manager of BankWest, is that right?
Yes, the credit risk assessment itself is undertaken normally by the relationship manager. In this case, that occurred. And then there is a response to that credit risk assessment separately provided by the business credit team within the risk management function.
It goes to a manager to approve the credit risk assessment, is that right?
That's correct.
And it's the relationship manager who performs the credit risk assessment initially who has the ongoing contact with the borrower, is that right?
That's correct.
And it seems as if those assessments were completed on about a quarterly basis for this business.
Yes.
Is that, do you know, normal, or was that a reflection of any particular risk in relation to this business?
No, my understanding this was in the relatively normal cycle of preparation of credit assessments.
Now, in the months leading up to the approval of the overdraft, BankWest made an offer to the Stanfords to vary the terms of their business loan.
Yes, in January 2010.
And that wasn't accepted by the Stanfords.
That's as I understand it, yes.
And then subsequently there was another letter of variation that was issued by BankWest.
That's correct.
And that appears to have been in identical terms.
Yes.
And it was then that second letter of variation that was accepted and signed by the Stanfords.
Yes, in July 2010.
And if we bring up paragraph 165 of your statement, which is on page 40, CBA.9000.0045.0040. Can we pop out 165? So just to take this in parts, the above offer, that was the offer in January of 2010, which hadn't been signed.
That's right.
And then the July offer is the one that was signed.
That's right.
And you say were made as part of BankWest's strategy to provide a simple to understand product range to its customers. Could you just, I wonder if this ties back to a point you were making earlier about trying to simplify the offerings. Perhaps it doesn't, but can you just explain what you mean by that statement, that it was part of trying to provide a simple to understand product range?
Yes, in conjunction with the BankWest straightforward banking strategy, the decision was made to discontinue a number of products, loan products that had existed to that point, and replace them with new products that were regarded as being more suitable for the type of lending that BankWest would embark upon in the future, being more straightforward lending to less complex businesses. And the particular product that the Stanfords first took out in 2006 was one of the products that was withdrawn and was replaced with one of these newer products. And it was intended that the products would be more suitable in a number of respects. One of the respects that was relevant here for the Stanfords loan was the base rate that was used for a portion of this loan. The fixed rate portion of the loan that the Stanfords had taken up was not based on the bank bill swap rate, and so the new documentation in both January and July 2010 moved the fixed portion of the loan to the bank bill swap rate base, which was a much more appropriate base for swaps or hedges than the base that the Stanfords had been on previously since 2006.
And what was the base they had been on?
So the base they were on was the bank bill rate, and the base that the January and July 2010 documents put forward was what's known as the BBSY, which is the bank bill swap rate, which is typically the base used for interest rate swaps or interest rate hedging.
And was changing from the BBR to the BBSY likely to increase or decrease the interest rate payable by borrowers?
I don't know actually at that time. I can't tell you what the relative rates were at that time.
And why was that likely to simplify the product range or the product from the perspective of the borrower?
From the perspective of the borrower, in this particular case, I don't see a great deal of difference in terms of simplification. Although the new the new facility terms of July 2010 reflected in fact the loan that the Stanfords had taken out. And I say that because the original facility had been based on a single amount of 1.2 million as the principal sum. A portion of that sum was subsequently fixed. And so in terms of the original facility, the Stanfords had a portion of their sum at floating rate, another portion at fixed rate. The July 2010 facility sought to simplify that by having part of the loan, approximately $601,000, at the floating rate, which reflected the then circumstances, and at the bank bill rate, being the base, and the second portion of the loan being approximately $460,000, I believe, at the BBSY rate, and that reflected the actual fixed portion that the Stanfords had at that time under the original facility.
All right, we'll come to the detail of the Stanford facility in a moment, just so we can assist the Commissioner to get a better understanding of the simplification of the product range. The original facility, which was the commercial advance was the commercial advance, is it INT?
INT, yes.
At maturity, that was being withdrawn, is that right?
That's correct.
And what does that mean in the sense that you've obviously already got a number of borrowers that are on that facility? Why is it necessary to switch them to a different facility rather than just letting them see out their existing facility?
It was regarded as I understand it, was regarded as preferable to have the borrowers switch out because in moving to a new product, there would be new systems that underpin that product. And I understand that it was considered better to try and have all of the products, or as many as products as possible, on the new system, rather than running two systems at once, namely the system dealing with the legacy products and a new system underlying or underpinning the new product. So it was, from an operational perspective, I understand, regarded as preferable to have as many products as possible on the one system.
It sounds like, from the answer you're giving, it's simpler for the bank to have everything moved onto the new system. Is that fair?
I think that's a fair statement.
I'm just wondering whether there's any simplification from the borrower's perspective.
The simplification from the borrower's perspective, as I understand it, was in the better monitoring and administration of the simpler products. So from a benefits perspective, if I can call it that, no, I don't see significant differences. But in the sense of how the loan was administered by the bank, statements, interest rate calculations, etc., it was regarded as better overall if the loans were on the new system that enabled better administration.
And as we understand it then, for many loans, if they were already on the commercial advance INT at maturity, the bank would seek to switch them over to this commercial advance multi-limit. Is that right?
That's correct, yes.
And so, in general, regardless of anything else, the bank would have sought with the Stanfords to switch them over to this new type of facility?
That's my understanding, yes.
Do you understand there were some other things that the bank was seeking to achieve by switching the Stanfords over to this new facility?
Not that I'm aware of, no.
All right. And then if we bring up paragraphs 166 and 167 of your statement, which is on the following page. Just the next page. Thank you. You're explaining here your understanding of the nature of the variation that was offered to the Stanfords.
Yes.
And you say at the end of the chapeau of paragraph 166, the new facility split the original facility?
Yes.
And does that mean your understanding, or perhaps should go back a step, as you understood it, it was already split in the sense that there was a fixed and a variable interest part of the loan?
That's correct.
And so the change that's made with this new letter of offer is what, as you understood it?
The change made was that original facility, comprising a total of 1.2 million loan, had not formally previously been split into two loans, one for the fixed, one for the variable. This July 2010 facility formally split them into two distinct loans, one for $601,000 being at the variable rate, one for $464,000 being at the fixed rate, and each of them using different base rates, given that one was variable and one was fixed.
And perhaps I think we'll need to go to the documents to see this in a bit more detail. But at a general level, the point that you're making is you understand that although there was a fixed and a variable component, there had not been a formalisation of the splitting of those loans into a fixed and a variable component. Is that what you're saying?
Not the underlying loan. There had been a formalisation, as I understand it, of the fixed portion in the form of an interest rate swap, so that was formal.
Yes.
But the underlying loan that backed, if you like, the interest rate swap was not specific to that interest rate swap. It was a loan of a much larger amount than the amount of the interest rate swap.
I see. The interest rate swap only affected a portion of the loan, not the whole of the loan.
Of the original loan, that's
Of
correct.
the original loan. The effect of it was that 406, as at this date, July 2010, $464,930 of the loan was fixed. That
Correct.
was the existing effect of the interest rate swap.
That's correct.
But there hadn't been a formal split into two separate loans, one of $601,000 and one of $464,930.
That's correct.
So in substance, this formalisation of the split didn't change the position of the Stanfords.
No, that's my understanding.
And then you say in paragraph 167 that it was a condition of this new facility that there would be additional standard reporting requirements?
Yes, so some of them were not additional. Some of them were putting in place in the new facility arrangements that had already existed. For example, in 167B, the requirement for quarterly management accounts was not a new requirement, it was an existing requirement, but it was formalised in this facility.
And I just want to understand what you mean by that. We can go back to the 2006 loan if that would assist, but there wasn't a quarterly reporting requirement formally in the 2006 loan?
No, there was not. That came later.
And when do you understand that came in?
My understanding is that the first requirement for quarterly reporting occurred in around August 2009, and then that was an informal arrangement. As I read the documents, it's one of my exhibits. I think it's DC 88, there was an informal arrangement struck between the relationship manager and Mr. Michael Stanford to provide quarterly management reports, and that was discussed between the relationship manager and the Stanford's accountants in order to provide those quarterly management accounts. That was the first occasion. And the second occasion was in the overdraft facility of April 2010, when the quarterly requirement was formally documented for the first time, as I understand it.
As part of the overdraft?
As part of the overdraft, that's right.
And just if we take the first part of your answer, which was relating to 2009, in 2009 you understand that the relationship manager was seeking quarterly reports from the borrower?
Yes.
And also, it seems, from the accountant?
Yes, as I understand it. And as I understand the commentary in that particular exhibit, that was agreed to by Mr. Michael Stanford.
But there wasn't a contractual term of the existing facility that required the Stanfords to provide those quarterly reports?
That's correct, yes.
And so a failure to provide the quarterly reports wasn't a breach?
At that point, no.
All right. And so the effect then of this new 2010 loan was to include a formal requirement for quarterly reports, a formal contractual requirement for quarterly reports?
In the facility for
Yes.
the two Stanford brothers, yes. But the previous contractual obligation was in the overdraft facility
Yes.
with Let It Rain.
Yes, for the $20,000 overdraft.
Correct, that's right.
This now included a quarterly reporting in relation to the loan that was made to the Stanford brothers.
Correct, the larger loan, yes.
And I don't think we're disagreeing, but that was a new contractual obligation on the brothers.
In respect of that loan, yes.
All right. And another effect of the new facility agreement was that it brought in an increase to the margin being charged on the variable portion of the loan.
That's correct.
And if we bring that up, it's CBA.4000.0037.5077. So this is the 2010, this is the July 2010 offer.
Yes.
And if we go to page .5078,
Yes.
we see the interest rate for the variable portion is now bank bill rate plus a margin of 1.93% per annum.
That's correct.
And the previous margin had been, was it 1.18%
That's
per
correct,
annum?
yes.
All right. And the change in margin, do you know what the reason for that was?
My understanding from my review of the documents is that it was felt at that point that there were concerns around the business, the operations of the business, the trading performance of the hotel. And as I understand it from the documents, there was a concern that the risk that was being taken by the bank as a result of that deteriorating trading performance was greater. And therefore that was reflected in the new pricing, which was a 0.75% increase.
And perhaps if we go to DC-93, which is CBA.0001.0285.0518. So this is a response from the relevant manager to the submission of a report or credit submission by Mr. Goldsmith, is that right?
Yes, that's right.
And this is the response in December of 2009.
Correct.
And we see here that what occurs is that the risk grade is downgraded to 6+.
Yes.
And you'll recall we've looked already, the original risk grade was 5.
Yes.
And then we see in the fifth bullet point, pricing to be increased now.
Yes.
And it says as LOV, that's letter of variation, is that
That's
right?
correct.
Needs to be issued for change of product in line with matrix to cover long-term funding premium.
Yes.
And so this suggests that as at December 2009, what the manager was requiring as a condition of the approval of the credit submission was that the letter of variation that was to be issued to the Stanfords would have an increased margin. Do you agree with that?
Yes.
And we'll see, we'll come to this in a little bit more detail, but what happens is that that letter of offer that goes out in January of 2010, it has the increased margin in it,
That's correct.
but the Stanfords don't sign that letter.
That's correct.
And if there was no attempt being made to have the Stanfords sign a letter of variation, would you have expected that the pricing would nevertheless be increased?
I'm not sure that I can... I would be speculating, but if you don't mind me speculating,
Yes.
I would expect that at some point, given the concerns that were expressed at this stage, being December 2009, I would have expected that at some stage, and I say this with the benefit of hindsight because I've seen what happened in 2010, but I would have expected at some point there would have been a discussion between BankWest and the borrower about pricing in view of a concern about the increased risk that the bank was taking.
And does that carry with it the notion that it would need to be a consensual agreement to increase the pricing?
I think, again, I'm sort of speculating as to what would generally happen. But generally speaking, there would be a discussion where I think it's fair to say the bank would suggest, rather than ask permission, the bank would suggest that the interest rate should increase in order to reflect the view that the bank had at that stage of the credit risk that it was taking.
And if the borrower didn't take up the suggestion, what then would BankWest have to do?
Again, at a general level, if you don't mind me sort of
Yep.
speculating, because I'm not tying it to this specific case, at a general level, BankWest would make a decision as to whether or not the price should be increased. That might depend on a number of factors. The strength of the relationship with the borrower would definitely be one. As I've mentioned, BankWest's view of the credit risk that it was taking in view of the deteriorating circumstances would be another. Those factors would go into the mix, and BankWest would then decide whether it was going to implement, as opposed to seek permission, whether it would implement a price increase or not.
By exercising the unilateral power of variation.
That's
that we
correct.
have under the contract.
That's correct.
Right. And then if we go to DC 94, which is CBA.0001.0285.0983. Now this is what appears to be quarterly credit risk assessment performed by the Stanfords relationship manager.
Yes.
And if we go to page .0988, we can see it's completed on the 26th of March 2010.
Yes.
And then if we go back to the first page, .0983, we can see the risk grade for each of the facilities is given as 6+,
Yes.
and that reflects the memorandum we saw before from the manager.
Yes, that's right.
And a 6+ risk grade, as we understand what you've set out in your evidence, means it's still a performing loan.
That's correct.
And I just want to understand one aspect of some evidence you gave earlier. You see, this is listing 3 facilities.
Yes.
And the third facility is that business bonus account that's to have an overdraft. The first facility is what appears to be the variable interest rate facility. The second facility, is that just the swap facility? It's not, is that right?
That's correct.
And I'm just trying to understand that idea, or the point you made before, which is that before they signed the letter of variation, there was no split into 2 facilities of the what was originally $1.2 million and had now been paid down, because on the face of this, it looks like it has been already split in some way.
Well, it's been split in the sense that a swap was put in place, and that's why it's separately itemised in this list,
Right.
so that because it had a separate interest rate applying to it, it was necessary to separately itemise it.
Right. And then we see there's a heading about 1/3 of the way down the page, which is safety.
Yes.
And you see that number 7 is loan is secured 100% by value of security at SLM. What does SLM stand for?
SLM means the safe lending margin, sometimes called the secured lending margin.
Right. So it says loan is secured 100% by value of security at safe lending margin, and the answer is yes.
Yes.
And so that means as at this point in time, March 2010, the loan to the Stanfords was still within BankWest's lending policy margins.
That's correct.
And then at the bottom, we see number 10, financial and information undertakings adhered to.
Yes.
That says yes. I'm not sure that that's actually correct, is it? By then there'd been some delay in providing annual reports, is that right?
Yes, that's my understanding.
But not something that presumably materially affected anything concerned with the viability of the loan.
I think that's probably right. I think it more goes to the general conduct of the account, which I think is why the answer to question 3 on that page was no.
Yes, that is, the general account conduct has been satisfactory over the last 12 months, and the answer is no.
That's correct.
And then if we go over the page to .0984, so we see the second bullet point under change sort is request for overdraft.
Yes.
And then 3/4 of the way down the page, there's a paragraph that begins since date of last report.
Yes.
And that seems to be explaining that since the last report, which was at the end of 2009, the new letter of variation to change the product over has been issued.
Yes.
And that was delayed until the 15th of January because of a backlog at CSE. What's CSE?
CSE, I understand, is the administration area of BankWest that was responsible for issuing
The letters of
documentation.
variation.
Yes.
And it's then explained that Mr. Goldsmith had attempted to contact the Stanfords with no real success and finally arranged a meeting for the 10th of March 2010.
Yes.
And then if we blow up the remaining section of the page from in this meeting, what Mr. Goldsmith is recording is that in the meeting, Mr. Stanford expressed a concern that the bank was looking to exit the pub.
Mr. Michael Stanford, yes.
And That's right. The witness yesterday was Brendan Stanford.
Yes, yes,
And that the reason Michael Stanford held that suspicion was because of various matters that are listed there.
yes,
And Mr. Stanford thought that the transfer of him from the old account to the new account was part of the effort to move him on.
yes,
But Mr. Goldsmith assured him that that wasn't the case.
yes,
And certainly at this point in time, there's nothing to suggest that Mr. Goldsmith, the relationship manager, was looking to move on the Stanfords from BankWest.
no, not that I'm aware of.
And if we go then to page .0986, and can we just blow up the section which is ratios? About 3/4 of the way down the page. What Mr. Goldsmith is recording is that the ratios, which is that ICR and DSR that we've looked at earlier,
Yes,
they've been met for this quarter, but that's the first time that they've been met since BankWest has been measuring the ratios.
yes,
But even though the ratios were below the guidelines in 2008 and 2009, it hadn't been to an extent that caused concern about the viability of the hotel.
that's right.
And then if we go over the page to .0987, and we see there's a section at the top of the page which is ATO arrears. And can we
Yes.
blow that up? BankWest had been made aware by the Stanfords, or by Michael Stanford, that they had arrears in their payments to the ATO.
Yes,
That, I imagine, is typically a sign of concern to a bank if one of their borrowers is in arrears to the ATO.
it can be of concern, primarily because it can suggest that even if the payments by the borrower are up to date with the bank, it can suggest that other obligations are not being met in order to fund the payments to the bank. And it therefore gives an indication that there's some financial difficulty that the customer may be experiencing, albeit that's not translating into a shortfall of payments owing to the bank. And so the concern is that perhaps while the bank payments are being met, other payments are not being, and that indicates in this case, potentially a trading difficulty.
In this case, the borrowers had explained that they'd entered into a payment arrangement with the ATO,
Yes,
and they provided copies of the tax portal statements,
yes,
and those statements showed that they were up to date
correct.
with their payment plan.
That's right.
And you see there's then a heading which is request for overdraft, $20,000 on account.
Yes,
And there's a setting out of a number of numbers showing the run of the account.
yes,
And then it's explained, or the summary from Mr. Goldsmith is, excesses are usually of a short duration and clearances come from receipt of ATM clearances and BWAMS fees.
yes.
Do you know what BWAMS fees are?
Yes, I understand that was BWAMS, I believe, was the provider of the merchant facility. So the merchant facility attached to, say, the FPOS terminals that were used in the pub. So fees would have been payable to that provider of merchant facilities. I believe that's what it's referring to.
Sorry, you think the business Let It Rain is making a payment to the provider of the merchant facilities?
Well, I think what it's saying is that the excesses are cleared in due course, usually not after a very long period, when the merchant facility provider, namely BWAMS, sends payments through. Quite often merchant facility providers don't make the payment on the same day that the payment is made by, say, a patron of the hotel. So if a card payment is made at the hotel, the card payment is processed through the payment system by the merchant acquirer, in this case BWAMS, but the payment isn't necessarily forwarded to the account of the merchant, in this case the pub, on the same day. It might be several days later, and so there's a delay in receipt of that money, and I think that's what this is referring to.
Right. And the overdraft in any event was granted by BankWest?
It was.
And then if we go to Exhibit DC-95, which is CBA.0001.0285.113. So this is, again, the manager business credit form that's provided in response to that report that we've just looked at from Mr. Goldsmith.
That's correct.
And he's approving the decision by Mr. Goldsmith to be able to provide the overdraft facility.
Yes.
And he notes some concerns, though.
He does.
And one of the conditions he opposes is that the account is to be maintained on the early warning watch list.
Yes.
And we spoke about that yesterday afternoon, the introduction of the watch list by BankWest in order to properly monitor and manage its loans.
That's right.
And he also makes the comment that while servicing is seen as acceptable, I think this is saying existence of ATO liabilities do not provide comfort. Does that mean he's concerned, or you're just not sure?
I have interpreted that to mean that the ATO liabilities of $61,000 make him uncomfortable.
Yes. That's right. It's do not provide comfort.
Yes.
Yes. All right. And then if we go to, I'm sorry, I should just confirm, there's then, once the overdraft facility is granted, there's a guarantee that's provided of the overdraft facility by each of the Stanford brothers. Is
That's
that
correct.
Right?
Yes.
Right. And as at March 2010, the Stanfords had continued to make all of the principal and interest payments they were required to make under their loan from BankWest.
That's correct.
And in fact, they'd paid down more principal from their loan than they were required to, just making the ordinary payments.
That's right.
And then in April and May, the Stanfords business loan and the Let It Rain overdraft were reviewed as part of Project Magellan.
Yes, that's right.
And we go to DC 103, which is CBA.0001.0285.1114. This is the Project Magellan file review in respect of the Stanfords.
Yes.
Can I ask a question about total assessed exposure? The total assessed exposure is said to be $1.161 million.
Yes.
Is there some other amount that gets added on in addition to just the outstanding loan balances in order to arrive at total assessed exposure?
Commonly, total assessed exposure would include the amount which the borrower could borrow from the bank, even if at that point it had borrowed less. So the limit, if you like, might still exist even though the amount borrowed is less than the limit. I'm not sure if that's the case here.
And this also then ties into something which is, you see the first bullet point under key credit events.
Yes.
What's said is that a CRS, which is credit review submission, is that right?
Yes.
Was submitted seeking TAE $1.416 million. So that's back in August of 2006. We know and it says that was approved, but the loan was for $1.2 million.
That's correct, yes.
Is there, it may be that you just can't help us with this, I don't expect you to be able to, but is there some explanation for what that difference is?
I don't know the actual facts. When I first saw this, I wondered whether the loan application at the time had been for $1.416 million, but the loan actually granted was less than that, namely $1.2 million. But it doesn't say that, it was just my guess.
And then on that first page, we see covenant compliant, and the answer is yes, but there's then some details. It says see below for details.
Yes.
And if we go then to page .1115, we see the third bullet point notes the tax arrears.
Yes.
The fifth bullet point says that financial information is provided directly by accountants who have been timely with information.
Yes.
And then the sixth bullet point is that the clients have breached the ICR and DSR covenants.
Yes.
And what that sets out, consistent with something we looked at before, is that they appear to have been breaching those covenants in 2008 and 2009.
Yes.
And then if we go to the bottom of the page, we see the overall summary being, we see connection as performing okay in the current environment, however requiring a higher degree of management as clients are upset at the closer management of the account.
Yes.
And am I right in understanding this part of the report is something that's prepared by the relationship manager or somebody that the relationship manager reports to?
Yes, this part, which I think I referred to in my statement as step one of the Magellan review process, was prepared by the relationship manager.
Right. And then if we go to .1117, so this is the independent review, what you refer to as step two.
Correct.
And this is being carried out by a partner of Ferrier Hodgson.
That's right.
And we see about halfway down the page that there's a point which is, in light of current trading, maintainable earnings for valuation purposes are seen as being $190,000.
Yes.
And that's the EBITDA plus $51,000 in add-backs for directors' fees.
Yes.
And then at the bottom of the page, we see going forward current earnings are sufficient to marginally service the debt.
Yes.
And then over the page on .1118, there's a section which is safety assessment.
Yes.
And the last two bullet points highlight something of concern, which is that the value of the hotel is likely decreasing given the decrease in EBITDA.
That's correct.
And that reflects something we were discussing a little earlier, which is something like this. It's an asset that effectively trades on a capitalisation of the maintainable earnings.
That's correct.
And so as the EBITDA goes down, which reflects the, assuming you use that as the measure, or in some fashion, the measure related to maintainable earnings goes down, then also the value of the property will go down.
Yes, and in conjunction with changing capitalisation rates, if that is present at the same time, it has a multiplier effect.
And one of the things that was happening, or does happen, is that the capitalisation rate, which had been, as this notes, 16 to 17% in the region was started to increase.
That's correct.
So that the capitalisation rate went from 16 to 17% to over 20%.
That's correct.
And then that also means that when you're applying that capitalisation rate to maintainable earnings, even if maintainable earnings remain the same, the value of the property would decrease.
That's correct.
And it said the current LVR is now seen as 90%.
Yes.
And then a little further down, we have a section which is risk assessments, risk mitigates.
Yes.
And it again notes in the third bullet point the ATO issue, which might indicate working capital difficulties.
Yes.
And then explains there's limited prospect of refinance in current market given the high LVR.
Yes.
And that there's a risk that the value of what is the security will further deteriorate unless performance can be lifted.
Yes.
And then as a consequence, the recommendation is that the risk grade be reduced down to 7.
That's right.
Sorry, and I should perhaps qualify that. It's numerically it's an increase from 6+ to 7, but in terms of the risk, that means it's a worse risk than if it was a 6+.
That's correct. We refer to it as the credit rating being downgraded,
Yes.
although the number goes up, as you say.
And then if we go over the page to .1119, these are the recommendations that come out from the independent review, and the project recommendation classification is double red.
Yes.
And could you just explain to the Commissioner, what does double red mean?
The ratings assigned to each loan reviewed under Project Magellan were green, red or double red. Red and double red indicated loans or loan files that were considered to be higher risk.
And was there any difference in the way a red or double red loan was managed?
Well, for the purposes of the Magellan review, it was just an assessment as opposed to a management of the actual loan. Management of the loan would occur after the assessment.
The grading of red or double red would affect something you were talking about yesterday afternoon, which is when you come to make your collective provisioning, how do you consider these particular loans? Is that
That's
right?
correct. That's correct.
As distinct from it affecting any particular management step that you might take,
That's correct.
which was always going to happen after Project Magellan.
That's correct.
And then if we go to page .1121, this is the panel decision, which you've referred to as the third step of the Project Magellan process in your statement.
Yes.
And the panel decision in relation to this loan is to accept the risk grade of 7,
Yes.
to classify the loan as red rather than double red,
Yes.
and the recommended actions are said to be as recommended in reviewers' future actions.
Yes.
And if we then just go back to page .1119, so the future actions that have been outlined by the reviewer are 1, to obtain confirmation about trading in May 2010,
Yes.
2, to ascertain an update on cash flow of repayment arrangements.
Yes.
And just pausing on that, there hadn't been any default in making repayments as at May 2010, had there?
No, they had not. I had read that, perhaps incorrectly, as an update on the ATO repayment arrangements.
Repayment arrangements.
Yes.
I understand. And in any event, there hadn't been any default on the ATO repayment arrangements either. The third thing was to discuss the trading results with valuer to form an indicative view on value.
Yes.
The fourth point was to meet the customer to discuss the situation.
Yes.
The fifth point was to encourage the customer to put the hotel up for sale.
Yes.
And the sixth point was to maintain principal payments.
Yes.
And does it surprise you that the recommendation was to encourage the customer to put the hotel up for sale?
Not entirely, no.
And do you want to just expand upon that and explain why you say that?
Yes, certainly. I say that because looking at the situation as it existed at this point in time in 2010, given that there were concerns about the level of trading of the hotel, which was adversely affecting the EBITDA, and as we were discussing earlier, an adverse change in EBITDA together with a higher capitalisation rate meant that the value of the hotel was deteriorating. I'm not surprised at this recommendation because in light of those facts, I would have expected BankWest to have formed the view that potentially the only way for the borrower to be able to repay the loan was to sell the hotel and to sell it sooner rather than later, given the deterioration in EBITDA and the deteriorating capitalisation rates.
And then if we go to DC 96, which is CBA.0001.0285.1152. So this is another of these reports that are prepared by Mr. Goldsmith
Yes.
as the relationship manager.
Yes.
And this one, if we go to page .1155, is one that was prepared by him on the 15th of July 2010.
That's correct.
And if we go back to the first page, we see now the risk grade has changed to 7.
Yes.
And in terms of the margins, the margin for the variable interest facility was 1.18 and is proposed to be 1.95.
Yes.
But the swap rate is to stay at 1.18,
That's correct.
which presumably reflects what it's been fixed in at.
That's correct.
And if we then go over the page to .1153, if we look at the bottom of the page, which is non-receipt of 31 March 2010 financials,
Yes.
and the issue being raised by Mr. Goldsmith is that despite numerous requests from his office, he hasn't been provided with the financial information.
That's correct.
And then you see the statement at the bottom of the page, which is, regrettably, as clients have not signed new letter of variation, we are not in a position to breach clients, despite his acknowledgement that this information will be required on an ongoing basis.
Yes.
That might be a regrettable choice of words, as it turns out. When he says regrettably, what do you understand from that?
My understanding is that Mr. Goldsmith is of the belief that he is unable to send a breach letter in respect of the failure to provide the accounts for the period for March and for the end of FY 2010. He believes that he can't send a breach letter because the new facility agreement, which contains the formalisation of the requirement to deliver quarterly management accounts, has not yet been signed by the Stanfords.
And when you say he believes, does that mean you think he was incorrect, that he could have breached them for it?
Well, as I mentioned before, the overdraft facility contained the contractual requirement to provide quarterly management accounts, and it appears that he has forgotten that or was not aware of that.
And perhaps you might help the Commissioner to understand what would be the reason why he wants to be able to send a breach notice.
He would, my understanding is that he would want to have sent a breach notice in order to do two things. One, at a commercial level, to remind the customer or prod the customer to provide the accounts, because there was a formal notification that the facility had been breached, which was serious, and that the customer would therefore take on board the seriousness of that as a way of encouraging the customer to provide the missing financial statements. And the second, at the more technical legal level, would have been to reserve BankWest's rights in respect of that breach so that it could take action in respect of that breach in the future if it needed to.
And then if we go over to page .1154, at the top of the page, Mr. Goldsmith is making the point that he thinks that he has an issue with not getting back the letter of variation signed.
Yes.
And then the next point he makes is about making a request to increase the interest rate margin and decrease the commercial advance limit.
Yes.
And it appears as if what he's asking is for the margin to be increased, notwithstanding that the letter of variation hasn't been signed.
Yes.
And he says that he's seeking approval for that to happen at the next rollover.
Yes.
Could you just explain to the Commissioner what that means?
The rollover there is a reference to the base rate at which the commercial advance was calculated. It was calculated on the bank bill rate. The loan was funded through bank bills being issued and taken out by BankWest. Those bank bills have a tenor, depending on the period, and when the bank bill rolls over, that's the reference here to roll over. In other words, when the bank bill expires and a new bank bill is issued in the same amount for the same tenor, that's the rollover date.
And so is there any reason to think that merely by the rollover of the bank bills that would by itself mean that the margin on the bank bills, on the bank bill rate, could be increased?
Not by itself. My understanding is that the reference here to increasing the margin on the next rollover date is to avoid any break of that then existing bank bill, because a break incurs a break fee, which would be to the customer's account. And here the relationship manager is, as I read it, suggesting that any increase only occur at the time of the rollover, so that no break fee has occurred mid-bill, if I can call it that.
And I'm sorry, I'm not sure I understand. Why would increasing the margin on the bank bill rate cause a break of the bank bill?
Because the bank bill is for a fixed amount at a fixed rate for a fixed period.
Yes.
And so to increase the rate during that bill is changing one of those three fixed elements, and a change of a fixed element incurs what's called a break of the bill, and therefore there's a cost attached to breaking it.
We might be getting into something that takes us well beyond what we need to, but isn't the thing that is of concern here to Mr. Goldsmith the margin that is being charged on top of whatever is the bank bill rate?
That's right, yes.
And so the bank bill rate is the rate that's been locked in as part of that bank bill?
Well, the bank bill and the margin,
I see.
because you take out the bill for the rate
I understand.
that you are charging the client. So in this case, the base rate attached to the bank bill and the margin specific to this transaction.
And in order to do this would, in your view, just have to be the exercise of the unilateral power of variation. Is that right?
As I understand it, yes.
And then we see the next section is Magellan report.
Yes.
And Mr. Goldsmith is explaining his response to the various things that were the recommended actions that we looked at earlier.
Yes.
And as to that fifth one, which is encourage customer to put the hotel up for sale, he explains not seen as practicable
Yes.
and says client is aware that it is an option.
Yes.
And is it your understanding that the reason he says it's not seen as practicable is because of this issue in the relationship where the Stanfords, or Michael Stanford at least, already thinks that the bank is trying to get him to sell up? Or you're not sure?
I'm not really sure. I can't really say. I'm sorry.
All right. And can I just ask one other thing? Can we bring up, about related to this document, can we bring up CBA.4000.0037.5077, which is the variation of facilities? And if we go to page .5079, you got the,
This is DC 87.
yes.
Yes.
So if you go to the third page, which is 5079,
Yes.
and at the top of the page is the variable facility,
Yes.
and you see the interest rate is BBSY plus a margin of 1.23% per annum.
Yes.
Do you know why it is that the margin was going from 1.18% to 1.23% for the variable facility?
I don't know exactly why. I can hazard a guess, though, if you would like.
Is it because the bank bill swap rate is lower than the bank bill rate?
It's directly tied to the use of the bank bill swap rate as opposed to the bank bill rate. Yes.
And if we then go to Exhibit DC 97, which is CBA.0001.0285.1143. So this is the response from the manager to that report that we just looked at from Mr. Goldsmith.
Yes.
And he approves the recommendations that were made by Mr. Goldsmith, but he attaches some additional comments and makes some comments.
Yes.
And he also seems to think that quarterly data is not, he says quarterly data is not part of our letter of offer variation, and as such breach notice cannot be issued.
Yes.
I think your view is they've just misunderstood this.
I believe so.
And then the comment he makes is, I note amortisation is continuing, but lack of assistance from customers in providing data, non-return of letter of variation, etc., will result in bank withdrawing assistance, i.e. transfer to CAM with exit sort.
Yes.
And he notes the comment, encourage customers to put hotel up for sale.
Yes.
And then if we then go to what happens in the next quarter of 2010, can we bring up CBA.0001.0285.1221? I'm not sure that this is an exhibit to your statement, Mr. Cohen.
I think it might be DC 100. I'm not positive. It's a bit faint in this copy
Oh,
that
I'm
I've
sorry,
got.
you're right, it has a different That's a different doc. Oh no.
It's hard to tell from my copy. Thank you.
It appears to be a different document. So this is what's described as a BankWest credit risk form executive summary.
Yes.
And you see under customer overview, about a third of the way down the page, it says the industry is pubs, taverns and bars, and the industry attractiveness is amber.
Yes.
Can you just explain what that means?
Yes, I understand that to be an assessment using the red, amber, green measurement, that pubs, taverns and bars were considered by BankWest at this stage, being September 2010, to be a sector that was regarded as of some concern, but not the highest concern.
And the risk grade is 7.
Yes.
And the risk grade is 7, that's still a performing loan, is that right?
Yes, a risk grade of 7 is just before the stage of weak or watch list.
Right. And then if we go to the page .1225, this is dealing with the Magellan report. You see that about halfway down the page.
Yes.
And then you see there's again a response to this issue of encourage customers to put hotel up for sale.
Yes.
And it said previously this was not seen as practicable and as BC will acknowledge will be a difficult conversation. Do you know who BC is?
I believe that's a reference to business credit.
All right. However, I now consider that this is a live option following issues in the production of these figures, the results themselves and the sometimes contrary nature of the clients.
Yes.
And if we go back to page .1222, we see a section which is management ownership.
Yes.
And about a third of the way from the bottom of the page, you see credit history with BWA is mixed.
Yes.
Compliance history is mixed, particularly with reference to the provision of financial information.
Yes.
However, repayment history first class with no missed payments.
Yes.
Overdraft operating within arrangements, connection extensively reported upon since transfer to portfolio, August 2009.
Yes.
And what I'm interested in is your view as to whether it seems surprising that a borrower who has taken out a 20-year loan and is described as having a first-class repayment history is under contemplation to be approached to sell their asset?
No, it's not surprising to me
All right.
in this case.
And that is because you've identified already there's obvious risks associated with the performance of the business going down.
Yes, the financial indicators provided via the ratios, for example, the arrears with the tax office, the deteriorating performance of the hotel, all would have been very live indicators to BankWest that although payments were being maintained, nevertheless the underlying risk associated with this loan was increasing and the underlying financial condition of the borrower and the business were deteriorating.
Right. And then if we go to DC-101, which is CBA.0001.0285.1220, so this is the approval by the state manager of business credit in relation to the Stanfords.
Yes.
And you see the comment is, this connection needs to be exited ASAP. Please discuss files with customers and provide an orderly exit strategy by 30 October 2010.
Yes.
And then, in the absence of an acceptable exit strategy, the file will most likely need to be transferred to CAM at next review.
Yes.
And is it fair to say that from this point, that is from September 2010, BankWest had made the decision that it wanted to be out of the loan with the Stanfords?
No, I don't think so. I don't think that is fair to say that entirely.
Not entirely, did you say?
No, not
And what
entirely.
do you mean by that?
By that I mean that Mr. Bashar, in this case, the author of this particular document, clearly does have that view. But Mr. Goldsmith, the relationship manager, at various stages has disagreed with that view, and at this stage, as is evident from other documents, disagreed with that view.
And perhaps if we have I'm sorry, you're right then, I think I've put that badly. Let's have a look at some of that disagreement. Can we bring up CBA.0002.1959.7114? Commissioner, I should tender that document that I looked at before, which is CBA.0001.0285.1221.
And that's not the same as Exhibit DC 100.
It's not, no.
And that will, Exhibit 3.121 will be credit risk form, executive summary, 16 September 2010, CBA 0001.0285.1221.
And this is one of those documents, I think, that you're referring to, Mr. Cohen, an email sent by Mr. Goldsmith,
This is one of those documents, yes.
and he's responding to that recommendation by the state manager
That's right.
and says, in short, can look to have a report by end of week without too much problem, but do not agree with the fact we have to exit file.
That's right.
I tender that document, Commissioner.
Email Goldsmith to State Manager, 25 October 2010, CBA 0002.1959.7114, Exhibit 3.122.
And then if we go to CBA.0002.1959.8134,
Thank you.
this is a further email sent by Mr. Goldsmith to Daniel Hensman.
Yes.
And in this email, Mr. Goldsmith again expresses the view, he says, I would like to re-emphasise that we do not see this as an account for CAMs and or exiting.
Yes.
Debt is reducing and accounts are in order with clients highly committed to the hotel.
Yes.
So that was the view of the relationship manager.
That's right.
And when you referred to it not being the view of BankWest from September of 2010 that the account needed to be exited, you were referring specifically to the views expressed by Mr. Goldsmith.
That's correct.
Was
Yes.
there anybody else that you've seen expressing a similar view?
As Mr. Goldsmith?
Yes.
No, I don't believe so.
Attend to that document, Commissioner.
Email Goldsmith to Hensman, 15 November 2010, CBA 000219598134, Exhibit 3.123.
And then if we go to DC 108, which is CBA.0001.0285.1252. This is a further submission again by Mr. Goldsmith, and this is for the last quarter of the 2010 year, not financial year, calendar year.
Yes.
And Mr. Goldsmith, you'll see in credit risk grade, has said the existing credit risk grade is F3 and he's proposed that it be E2.
Yes.
Now that's switching, it seems, from the system that had been used to the BankWest by BankWest to the system that was used by CBA, is that right?
Yes, that's right.
And E2 means the credit risk is improving rather than being downgraded, is that right? Compared to
In
F3.
comparison to F3?
Yes.
That's correct.
All right. So what Mr. Goldsmith is suggesting is that the risks associated with the loan to the Stamfords are decreasing.
That's correct.
And then if we go to page .1253, he, at the end of the section on relationship strategy, explains the reasons for his request, and his request you'll see in number 1 and 2 at the top of the page. One is update BC, that's business credit, on the production of the 30 September 2010 management accounts.
Yes.
And 2 is remove the account from the weak list.
Yes.
And he explains his reasons for that. You've presumably looked at this document because you've exhibited
I
it.
have. Yes.
And that's not accepted. We'll see if we go to DC 109, which is CBA.0001.0285.1262. And the manager's position is that the file is to remain on the weak account list with a risk grade of F3.
That's correct.
And can I suggest about that, that's not necessarily surprising that there would be a difference of opinion between the relationship manager and the senior manager of business credit in relation to the risk with the file.
There are sometimes differences of view between the business credit team and the business team, in this case the relationship manager, so it's not entirely surprising, no.
Right. It's a matter of judgment and opinion.
It is.
You
And
said not entirely surprising. What do you mean by entirely? What's the qualification conveying, Mr. Cohen?
The entirely commissioner is referring to the fact that this sort of difference does arise from time to time. In other words, I'm not totally surprised that such a difference of opinion would exist.
Yes.
And then if we go to DC 112, which is CBA.0001.0285.1310, and we go to page. I'm sorry, I should just clarify something. This is a document prepared by Mr. Goldsmith.
Yes.
And if we go to page .1311, for relationship strategy, Mr. Goldsmith has now switched to a recommendation which is to transfer the file to CAMS with joint control.
Yes.
And in the end of that section on relationship strategy, he explains why that's seen as a necessary step,
Yes.
and then says the only counter to this is the fact that our debt is amortising and the clients have the expertise to run the hotel.
Yes.
And again, as at this point in time, which is the beginning of 2011, the Stamfords are still making their principal and interest payments,
Yes.
and the debt is still reducing.
Yes.
And they have a history of having successfully managed a previous pub.
Yes.
And if we then go over to .1316, the recommendation is that there be approval of the review of the financial statements that have been provided for the September and December quarters of 2010, is the first part.
Yes.
And the transfer of the file to CAMS with joint control,
Yes.
the risk grade to remain at 3,
Yes.
and the client to remain unaware of joint control.
Yes.
Do you know why it would have been recommended that the client remained unaware of joint control?
No, I don't.
Is that something that you would typically expect to happen in relation to the management of a borrower, that they wouldn't know that they'd been moved into CAM in the case of BankWest or the GCS in the case of CBA?
No, I would not. In fact, the policy in GCS is to specifically inform the client.
One possible reason, this is just speculation, but one possible reason is, as we've seen from the documents, Michael Stanford was very sensitive to the idea that the bank was trying to end its relationship with him.
Yes.
So it's possible that Mr. Goldsmith, who is obviously the person who is quite concerned about the relationship with Mr. Stanford, was concerned about what effect it would have on Mr. Stanford if he knew the file had been moved to CAM.
Yes, that is possible.
You haven't been able to speak to Mr. Goldsmith. He doesn't work at the bank anymore.
No, he doesn't. No.
And then if we go to the DC 114, which is the inward transfer credit paper, and that's CBA.0001.0285.1318. This is the transfer memorandum that gets prepared to send the file over to CAM,
Yes, it is.
and it's prepared by Mr. Goldsmith.
Yes.
And then if we go to page .1322, where it's additional issues, we see the fourth point, have raised issue of sale of hotel, however clients are not prepared to sell in the short to medium term.
Yes.
And then it says nil chance of refinance with breach fees charged on overdraft.
Yes.
Are you able to explain to the Commissioner what that means?
The nil chance of refinance?
Yes.
I understand that to mean that Mr. Goldsmith believes that another lender is unlikely, or actually not unlikely, will not refinance this loan. And my understanding is that he had that view on account of the deteriorating trading performance of the hotel with the resultant diminution in the value of the property. And therefore, another lender would be unwilling to lend the amount that the Stanfords owed to BankWest on the security of that hotel, which had decreased in value.
Do you understand what the reference to breach fees charged on overdraft is?
Yes. I've seen comments in some of these documents that upon a breach of an undertaking or a covenant by the Stanfords, on a number of occasions, BankWest charged a breach fee of $250, and I understand this to be a reference to one of those charges.
All right. Do the charging of breach fees have any effect on the likelihood of refinance?
I don't believe so, no.
All right. And then the file was transferred into CAM when, do you know?
Well, it seems to be at some stage between the date of this inward transfer memorandum in April through until June, at some stage between April and June 2011.
And what is it that happens in June 2011 that suggests that it's been transferred over?
I've seen a reference in a document that refers to the fact that it was transferred in June.
Right. And then having been transferred into CAM, CAM then commissioned PPB to do an investigative accountant's report.
That's correct.
It appears that that was done without having first consulted with the borrowers.
It appears that BankWest did not consult at all first with the borrowers, yes.
Before the accountants were appointed and arrived at the hotel.
That's right. I have seen the PPB engaging with Michael Stanford before they visited the hotel, but I've not seen BankWest engage with the customer at all.
And let me ask about that. Does that approach of appointing an investigative accountant without having first engaged with the borrower, is that something that CBA would do now?
No, definitely not.
Its policy has changed?
Yes, it has.
And when did that change occur?
I believe that policy first changed in 2016.
And is that a recognition that it is unfair to appoint an investigative accountant without having first consulted with the borrower?
I think it is. I think I should say that the policy did not change the practice. So although the policy came into place in 2016, it was not the practice prior to 2016 to never engage with a customer prior to the appointment of an investigative accountant. However, I believe the policy was brought in 2016 to underscore the fact that engagement must occur on all occasions with customers.
There must be a discussion with the customer about what it is that the bank is trying to achieve, for example.
Correct. And
Sorry, go on.
sorry. Well, the policy goes further. The policy stipulates that the customer must be informed as to why the bank considers that an investigative accountant should be appointed. Secondly, the customer is to be engaged around the scope and actually shown the draft scope of the investigative accountant's work. And thirdly, there's to be a discussion with the customer about the draft report. And then lastly, a discussion with the customer about the recommendations that flow from the draft report.
And in terms of your view about what occurred in this case, where the investigative accountant was appointed without there having been any consultation with the borrower, does it follow that you regard that as having been unfair on the part of the bank in its dealings with the borrower?
Yes.
And can we go then to DC 115, which is CBA.4000.0037.4936. So this is the report that was prepared by PPB.
Yes.
And if we go to page .4940, this is the at a glance section of the report, which sets out the two recommendations from PPB.
Yes. Yes.
And recommendation one was the borrower to put hotel on market for sale.
Yes, that's right.
And recommendation two was if the borrower is not cooperative, the bank should immediately enforce its security.
Yes.
And at this stage, when this recommendation is made, are the Stanfords still making their capital and interest repayments?
I understand so, yes.
And does it strike you as odd that the IAs would recommend that if the borrower won't put the hotel up for sale, the bank should immediately enforce its security, given that the borrowers are still making their principal and interest payments?
No, it does not.
And why is that?
Because the investigative accountant in this report has looked at the operation of the hotel business and has observed the lack of management skill in the operation of the hotel, has observed that there's a lack of basic financial disciplines, and generally the investigative accountant observed that a number of concerns about the operation of the hotel. So in the context of concerns about the operation of the hotel, firstly, secondly, concerns about the lack of a plan to improve the operations of the hotel, and I think in light of those, the investigative accountant took the view that the prospects for the borrowers to be able to satisfy their obligation to repay the loan as opposed to continue to service the loan in the context of a deteriorating trading performance was poor, and therefore I believe they felt that the only way for the borrower to be able to repay the loan was to sell the hotel and use the sale proceeds to pay back the loan.
Now, I just want to make sure we've identified some aspects of the opinion expressed by PBB. One is they raised concerns about the management of the hotel, which is what you've referred to.
Yes.
And that is whether the actual operation of the hotel is being managed adequately.
Yes.
And then a second issue connected to management that they raise is a concern about whether the financial management of the hotel is adequate.
That's correct.
And then a third issue that they raise is that there's a risk that the ATO will take steps to recover its debt.
That's correct.
Now, on that third issue, it appears as if they were unaware of the repayment plan. Do you agree?
Yes, I can't see any reference to the repayment plan in the IA's report.
And as far as you understand, were the Stanfords continuing to make their repayment, comply with their ATO repayment plan at this time?
I'm not aware of the status of their repayment plan at this stage, being September 2011.
All right. Commissioner, is that a convenient time? I've just noticed I've gone perhaps longer than I ought to have if you were going to take a short break.
Yes, perhaps if I come back at shortly after midday,
Thank you, Commissioner.
Mr Hodge. Yes, Mr Hodge.
Thank you, Commissioner. Now, Mr Cohen, what then happens is if we bring up DC 118, which is CBA.0517.0074.0003, there's a Gaydon's lawyers, who are the solicitors engaged by BankWest, send a couple of notices, and perhaps if we start with the one on, which is CBA.0517.0074.0007. So this is a notification to terminate the overdraft account.
Yes.
And then if we go back to CBA.0517.0074.0003, and this is a notification which raises a concern about the change in financial condition. We see that if we go to .0004, and it says, BankWest has received the independent investigative accountant's report into the trading position of the hotel.
Yes.
Having reviewed this report, BankWest is concerned that a change has occurred in the business's financial condition, which has had a material adverse effect on the value of its security property.
Yes.
And then it invites the Stanfords to let us know within 7 days of today whether you are prepared to acknowledge that there has been a material adverse change in the financial condition of the hotel.
Yes.
And asks them, if they don't agree, to outline the reasons why, in their opinion, there has not been a material adverse change, and provide financial records to support the position.
Yes.
Now, as I understand it, at least one aspect of this you would regard as unfair and inconsistent with today, Commonwealth Bank's policies today, which is the 7 days. Is that right?
Yes, as I've said in my statement, the policy that we have today is to provide at least 30 days' notice.
Do you also regard it as unfair to ask the borrowers to respond to a concern apparently arrived at from a report without providing a copy of the report?
Yes.
And so CBA today provide a full copy of the investigative accountant's report to the borrowers?
We would provide a copy of the report to the borrowers. We may excise from that copy sections that would be regarded as sensitive, namely commentary about the quality of management, because that can be quite emotionally confronting for a borrower. Secondly, we would probably excise any estimate of value of the security that would be realised on an enforced sale. And thirdly, we would definitely excise any commentary around the fraud of the borrower.
And so if we think about the report of PPB that we've looked at today, the section which is the recommendations, which are either the borrower sells the hotel or the bank enforce its security to cause the sale of the hotel, is that something that you would expect would be provided as part of the report to the borrower?
I would expect so, yes.
And the sections that express concerns about the quality of management, those are not sections you would expect would be provided to the borrower?
I would expect that those would probably be excised and not shown to the borrower.
And is one of the difficulties that creates that if the opinion of the investigative accountant, and therefore the opinion of the bank, is derived from the comments that are made about the quality of management, that it becomes effectively impossible for the borrower to be able to respond to those concerns?
No, I don't believe so, because the discussion with the borrower about the report would entail a view being expressed by the bank as to the capability of the borrower to trade their way out of a difficult situation, for example. So although the comments, written comments in the report, would probably not be shown to the borrower, the point of the policy that requires engagement with the borrower to talk about the report is aimed at ensuring that there is a discussion about the findings, albeit in not the black and white terms of the written report.
Is it possible, do you think, and we'll see this a little bit further with this case, that if the bank has set itself on a course of wanting to exit the loan rather than manage or become involved with the borrower so that the borrower's performance improves, that in that sort of situation, discussion of the quality of management would be irrelevant from the perspective of the bank?
No, I believe it would be relevant.
And then you see the next part of the letter says that the bank requires payment of the costs of the investigative accountant.
Yes.
And the borrowers are asked to pay the costs of $9,900 within 7 days.
Yes.
And again, I just want to, if we can, isolate the parts of this conduct that you think are unfair. Is the 7 days unfair?
I think so, yes.
And are there other aspects of this demand for payment that you regard as unfair?
Yes.
And what are they?
I think it's unfair to ask a borrower or demand from a borrower that they pay for a report that they've not received.
And if they received part but not all of the report, would that change the issue?
No, I don't believe so, provided that what is supplied to the borrower does give the borrower a sense of why the view has been arrived at by the investigative accountant and what the bank's response or intentions are in relation to the matter.
Now,
Well, I'm not quite sure what that means, Mr. Cohen. Can you explain your last answer rather more fully?
Yes, I think it's...
Excise parts of the report.
Yes.
How is the borrower going to, at that point in the life of the loan, have any comfort that he or she has a full understanding of what the bank has?
through the discussion with the borrower.
Yes, which would be conducted by whom?
That would be between the bank and the borrower.
The business relationship manager or someone who is new to the borrower?
It depends, Commissioner, on whether the file is being jointly managed by the business and the CAMS team or the GCS team, or whether it has been solely managed by the GCS team. If it was the former, then the conversation should be between the relationship manager, a member of the GCS team, and the borrower. If it was the latter, it would be between the GCS team member and the borrower.
Yes.
I want to show you another document, Mr. Cohen, which is CBA.4000.0037.4966. Just check whether that's in your statement. It's coming over to you anyway.
Thank you.
So this is an internal document prepared by, if we go to the last page, 4968, Mr. Maxwell,
Yes,
and he's said to be BankWest Risk Management, but that's within CAM, is that right?
that's correct.
And if we go to the front page, this is a document dated the 28th of November 2011.
Yes,
You see Mr. Maxwell notes at the bottom of the page in relation to Project Magellan in May 2010, current earnings were considered insufficient to meet debt obligations, no free cash for CapEx, LVR concerns, ATO repayment plan present.
yes,
So he's just summarising what it is that has been taken out of Project Magellan.
yes,
And then if we go over to .4967, we see at the top of the page, matter accepted into CAM June 2011.
yes,
And is this the document you think you'd been looking at that suggested that it had come in June 2011?
that's correct.
And the risk is downgraded to H2.
Yes,
So it was F3, it's now H2.
yes, that's right.
And what does that mean in terms of the change in risk profile?
So H2 is at the serious level of troublesome loan in terms of the risk gradings, with a probability of default, as it says here, of 100%. So the expectation is that there will be a default by the borrower in the next 12 months.
All right. And then if we go to the bottom of the page, we see IA report also draws attention to the lack of management ability demonstrated by the hoteliers, in particular their lack of internal reporting, inability to meet ATO requirements and overall deterioration in trade.
Yes.
Can I ask, does it seem odd at all that the investigative accountants would have thought there was a lack of management ability by the hoteliers, given that they've been managing hotels now for quite some time and have successfully managed an earlier hotel? Does there seem to be any perhaps lack of information on the part of the IAs that you would infer from that?
No, I don't believe so. My understanding is that the IA has made those observations based on their inspection of the hotel and its financial records, firstly, and have formed their view based on their experience in the hotel industry themselves. And in this case, the investigative accountant had specific expertise in the hotel industry.
Now, it doesn't appear at this stage as if there's been any actual failure to make repayments of capital or interest.
I think that's correct.
And we see in primary concerns in the middle of the page, the two primary concerns that are identified are material decrease in trading performance with direct negative impact to the bank's security position and significant level of historical breaches.
Yes.
but no reference to monetary defaults.
That's right.
And this is then referring to, or this refers to the fact that a meeting is sought between BankWest and the borrowers and their respective accountants and
Yes.
lawyers.
Yes.
And then I tender that document, Commissioner.
Memorandum 28 November 2011, Maxwell, BankWest Risk Management, CBA 4000 0037 4966, Exhibit 3.124.
And then if we bring up CBA.0001.0285.0009, I'm told it's DC 117. This is a CAM strategy paper for BankWest
Yes.
in relation to the Stanfords.
Yes.
And it's dated, we can see on the front, 16 December 2011.
Yes.
And if we go over to page .0010, can I just note one thing, which is you see the entry for October 2011. Oh, I'm
sorry,
sorry,
I seem to have a different-
1493, page 2.
Oh, I see. Yes, thank you.
I'm sorry, I've got two different document IDs. You see there's an entry which is October 2011,
Yes.
and it said Cam held telephone conversation with Michael, it says Stafford, but it should be Stanford, to discuss nature of findings, high-level concerns, and the need for the client to commence formulating a proposal for the bank to consider as a suitable way forward.
Yes.
So it does suggest that after the IA report was received by the bank spoke to Mr. Stanford.
Yes.
What it doesn't necessarily say is that they explained that there was a concern about the adequacy of what would be his management of the hotel.
Yes, I can't say from what's written here. It
But
doesn't say that.
I just want to understand what you would expect, at least now, the bank to do is
Yes.
to actually have that frank conversation with the borrower to say, we have a concern about the adequacy of your management
That's
of
correct.
the hotel. Is that right?
That's correct.
All right.
Yes.
And then you see at the bottom of the page, it says BankWest agreed to meet with the clients and their representatives. BankWest also had Gaydens present and also our agent PPB from an accounting perspective.
Yes.
And then over the page, it said that concurrent with the above meeting, the client, which is the Stanfords, had submitted a FOS complaint.
Yes.
And due to FOS complaint, enforcement action has ceased until FOS complaint is resolved.
Yes.
Do you understand what was the enforcement action that was under contemplation at this point?
I don't know what was in contemplation at this point, no.
If you look down under the heading provision, you see there's what's described as an upside case, a likely case, and a downside case.
Yes.
And you see the upside case assumes no appointment over hotel, minimal legal fees on enforcement with borrower selling down.
Yes.
Hotel after a period of trade on with new support structure and tight controls.
Yes.
So the upside case that appears to be envisaged by CAM is that the borrower will sell the hotel.
That's correct.
And then the likely case assumes appointment over hotel, trade up period of 5 to 6 months.
Yes.
And assumes appointment means the appointment of a receiver to the hotel.
I understand that. Yes.
And then downside case assumes appointment over hotel, no improvement in trade.
Yes.
And that is, again, assuming the appointment of a receiver.
Yes.
It doesn't appear to be the case that one of the options that CAM considered was that the borrower be able to continue to make payments of principal and interest of their 20-year loan. Do you agree with that?
Yes, I do.
And does that seem strange to you?
No, it does not.
And why is that?
Because it appears to me that at this stage the view had been taken that the deteriorating performance of the hotel business was going to, and other aspects such as arrears with the ATO, was going to lead to a default in due course, notwithstanding the fact that at that point in time the principal and interest payments were continuing to be made on time as scheduled.
What I wonder about there is whether you would have an expectation, or the bank would have an expectation, that CAM in that circumstance would at least contemplate the possibility of trying to engage with the borrower to prevent a default.
Yes, indeed. And that is one of the primary roles of the CAM or the GCS team, is to try and rehabilitate a loan in order to avoid a default, or in order to avoid a default leading to a worse situation.
And in this case, have you seen anything to indicate that CAM attempted to work with the Stanfords to try to avoid a default?
The evidence that I have seen relates to the period from about this stage onwards, following discussions brought about by the FOS dispute raised by the Stanfords.
I'm sorry, I'm not sure you're quite answering my question, but you may be. Are you saying you have seen evidence after 2011 of CAM attempting to work with the borrowers to prevent a default occurring?
Yes, but I should clarify, not by way of the borrowers improving trading to the point where it could continue to trade, but rather by way of agreeing a timetable for a sale of the hotel, with the sale intended to prevent a default further down the track.
I understand. And that's in 2014, isn't it?
I think from about 2013, early 2013 onwards.
All right. Can we bring up CBA.0001.0285.0119? This is, I expect it's being handed over to you. It's a strategy paper dated the 12th of April 2013.
Thank you.
And it seems to be a strategy paper from and to Ms. Frager.
Yes.
And she is now, by this time, the senior manager from CAM in charge of managing the Stanfords.
Yes.
And you see in 1.1, she identifies the purpose of the strategy paper, which is to expedite the realisation of the asset, seek approval to enter a deed of forbearance with the borrower with the aim of exchanging contracts by 15 June 2013,
Yes.
with a further extension of up to 3 months to be considered if the borrower is able to demonstrate genuine hardship.
Yes.
And that, I think, as I understand what you say, is consistent with what you've observed about the approach of CAM in this case, which is, insofar as it's a strategy of preventing default, it's of preventing default by getting the borrower to sell the asset. Is that right?
That's correct. Yes.
And the reason, if we go over to page .0120, and we look down at paragraph section 4 at the very bottom of the page,
Yes.
the view that has been taken by Ms. Fragar is the current debt level is not sustainable, therefore the strategy is to exit as soon as possible,
Yes.
and therefore the only option is sale.
Yes.
And she then talks about how it might be possible to expedite the FOS claim so as to then bring about the sale of the property.
Yes.
And then if we go over the page to .0121, when she's talking about the timing of that, she notes in 4.4 that there may be a need to provide a further concession given the hardship of the borrower.
Yes, of Mr. Brendan Stanford, yes.
Because he'd been admitted to hospital.
That's right.
And I tender that document, Commissioner.
Strategy paper 12 April 2013, CBA 0001-0285-0119 is exhibit 3.125.
What appears to be the case, Mr. Cohen, looking at these documents, is that the bank, with perhaps the exception of Mr. Goldsmith, sets itself on the course really from September of 2010 to have the pub sold. Do you agree with that?
Yes, there are the credit, business credit people seem to have that view from about that point onwards, yes.
And then when it comes to CAM, that's also the approach that CAM takes.
Yes.
It doesn't appear as if CAM contemplates the possibility of trying to, in some fashion, work with the Stanfords to rehabilitate the situation.
I think that's correct, yes.
And it may be, reflecting what we've seen in Ms. Fragar's memo, that that's because they view the situation as hopeless.
Yes.
And I just want to understand from the perspective of the bank now, is this method of managing a borrower something that the bank regards as acceptable?
Can I just clarify, when you say this method,
Yes.
do you mean
This approach.
not having as an option the borrower continuing to trade?
Yes.
In cases where the bank considers, with the benefit of expert advice, but also on the basis of its own experience, that the situation is irretrievable for the borrower, I think it's acceptable for the bank to go down the course of another course rather than repatriation, yes. I do think, however, that a full and frank discussion should be held with the borrower about that view and why that view has been arrived at.
And so in terms of your view about the management of this case, and we haven't yet come to the offers in 2014, so
Yes.
set those aside for the moment. But when it comes to your view about the way in which the bank managed this case through to 2013, do you regard the management as acceptable?
I think the management of it was acceptable in some but not all respects, and I do think that better management should have been applied here, particularly in terms of a more fulsome discussion with the borrower about the reasons why the bank considered that a sale of the hotel was the only viable option in order to enable the borrower to repay the loan.
And should that discussion have related expressly to terms of the facility as they were agreed at the time of its making?
I think so, Commissioner, yes.
The terms as they were agreed and then varied, did they include any term as to LVR?
No, they did not.
Therefore, to speak in terms of irretrievable outcome is to speak about final discharge of the loan at what point? At term? Before term? If it's before term, it must be on account of breach. So it's in anticipation of breach, is it?
So it would be before term, Commissioner, yes, it would.
And in anticipation of breach, because breach has not hitherto occurred, has it?
Breach had not occurred in respect of LVR because there was no LVR covenant, that's correct. Breach had occurred in respect of the interest cover ratio and the debt service ratio.
And do we find in any of the communications to the borrowers, other than the issue of notices, explicit reliance on default in those provisions as reasons showing why the bank wished to accelerate to the point of realisation?
Not that I'm aware of, Commissioner, no.
Should the bank have adverted to those matters in the course of its discussions with the customer?
I think that would have been helpful to the customer, yes.
Because the customer will no doubt have a particular point of view about the dealing, and human nature. Of course the customer will see it through a particular prism. But a dominant shaft of light through that prism, I suspect for the customer, will be, I kept paying my principal and interest.
Yes, I agree.
Well, is it right that the bank should, or would it be better if the bank had said, maybe so, you're paying principal and interest, but interest cover and debt servicing ratios are out of whack. Those are warning signs showing us that this is a path to disaster.
Yes, I agree.
Go on, Mr. Hodge.
Thank you. And to be fair to you, Mr. Cohen, it was the case, wasn't it, that after 2011 there were monetary defaults in relation to the loans?
Yes, there were, yes.
The principal continued to be paid, but there was an issue around the interest.
That's right. Well, to be precise, principal at that point, 2011, continued to be paid. There were some interest shortfalls. And then, unfortunately, as the matter progressed into 2013 and 2014, there were some principal shortfalls as well.
But throughout that period, the bank was never, as far as we can see from the documents, engaging with the borrowers on the premise of, can we try to get this back to being a performing loan where you're making principal and interest payments?
That's my understanding, yes.
The approach to the bank was unequivocally that they wanted to have this property sold.
That's right.
And do you accept that one of the consequences of a bank approaching borrowers in this way is that it imposes a lot of stress on the borrowers?
Yes, I do.
And do you accept that for the bank to take that approach is unfair in this case?
I think in this case, the lack of discussion with the borrower, the lack of explanation about why the sale of the hotel was the only option, I think that was not reasonable and not fair to the customer. Unfortunately, the fact is that a sale of an asset is always going to be extremely difficult. The sale of the main undertaking is going to be extremely difficult, and I think from a human point of view, in terms of the fact that undertaking a business such as this for the Stanfords was really at the centre of everything they did, everything they were focused on. I think's better understanding of that position in the form of more open discussions around why the sale option was perceived to be the only viable option would have been far preferable, yes.
And do you think, in terms of what the community expects, that the approach of the bank would fall, in this case, would fall below community expectations of a bank?
I think community expectations today would require that the bank have a more open and transparent engagement with the borrower in circumstances such as this.
Do you think one of the difficulties from the community perspective with understanding the bank's approach in this case might be the fact that the loan is a 20-year amortising loan? It's not a 2-year rolling facility for property development.
Yes, I think that might be one of the difficulties in terms of community understanding. I think another difficulty which is I think very difficult to understand generally, is that the use of non-monetary events of default, or in this case financial ratios, can be a very powerful indicator of trouble to come. And that's not an easily understood concept, I acknowledge, and therefore is not necessarily embedded in community expectations. I think in this case, the community expectation would be focused on the fact that payments were continuing to be made, at least up until a certain point. And the expectation, I think, is that if payments continue to be made, then the bank should not be taking any action.
I'm going to show you another document which I think your legal team think might be relevant. Can we go to DC 125, which is CBA.4000.0037.5460? And this is Ms. Shable, I think, that's her maiden name. She then becomes, she continues to be Ms. Fragard,
Yes.
manager. And this is an email that she sends to herself on the 14th of November 2012.
Yes.
And it's a file note of a conversation with Brendan Stanford.
Yes.
And she's noting that the facility is currently outside of arrangements.
Yes.
And that they need to determine whether we can return to the facilities to within arrangements, if not need to sell the business.
Yes.
And Mr. Stanford, that is Brendan Stanford, is saying that the strategy remains to sell the business.
Yes.
And Ms. Shable says her next steps are to seek approval to agree strategy, providing borrower with one shot to sell the asset according to the strategy.
Yes.
If the asset does not sell, seek to enforce immediately with sale as soon as possible.
Yes.
I'm not sure that that affects any of the observations that you've made, but your lawyers would like it pointed out to you. Is there anything that you want to comment on about that?
Well, the two comments I would make is that according to the note, the discussion with Mr. Stanford, at least in part, focused on whether the facilities could be returned to within arrangements, which I believe is a reference to ensuring that financial records were provided on time in accordance with the contractual arrangement. Secondly, to ensure that the interest cover ratio and the debt service ratio were within the measures set out in the agreement. So there does seem to be there a sense, at least in the discussion, that could the arrangements be returned to performing arrangements. The second thing is that it appears from this note that the borrowers did have an intention to sell the asset. So at least in that sense, the bank's view that the asset needed to be sold in order to repay the debt, and the borrower's intentions appeared to be somewhat aligned at that stage.
Yes, although I'm not sure why, but it's almost as if your lawyers are laying a trap for you, because the problem is this is the end of 2012, and by this stage there's been a year of the or more of the bank putting it on the borrower to sell the asset. Do you agree?
That's right. Yes, I do.
And you heard Mr. Stanford give evidence yesterday, which is it was apparent to him what the bank wanted, and he wanted to try to sell it on his own terms.
That's right, yes.
And certainly when you look at what the next steps are that are identified, there's no suggestion that there'll be some focus if the asset can't be sold by the borrower on trying to rehabilitate it.
No, I agree with that entirely.
The
Yes.
strategy is if they won't sell it, then we will.
That's correct, yes.
And then I want to then ask you some questions about the offers that are made at the very death. Now, you know that what happens in January of 2014 is that, consistent with the strategy we've seen already, a deed is entered into that gave the Stanfords until the 30th of June 2014 to auction the property.
Yes.
And there was engagement with an agent by both the bank and the Stanfords.
Yes.
And there was a marketing proposal put together,
Yes.
and the Stanfords at that stage had a debt to the bank of about $1 million.
Yes, I believe so.
And the marketing proposal suggested that the sale price of the property would be, at auction, would be something a lot less than that.
Yes.
We'll go to this in a moment, but the asset sale would end up being between $550,000 and $615,000.
Yes.
And as it got towards the 30th of June, the property hadn't gone to auction, and there was obviously a disagreement about the Stanfords wanted to realise something from the property different from what seemed to be a realistic assessment of the market price.
Yes, it appears so, yes.
And so an offer was made, which we saw in evidence yesterday, and we might bring that up, which is CBA.0517.0118.0001. And the offer made on the 26th of June 2014 was, there were a few different alternatives, but the primary alternative was to restructure the bank facilities. I'm not sure that that's in your documents, Mr. Cohen. I don't think it is, but we tendered it yesterday. I think it's just being run over to you now.
Thank you.
So this is, the top of the page is the response from BankWest, but at the bottom of the page the offer begins, and if we go over the page to .0002, the bank's asked to consider a restructure of the facilities with a few different elements, but one of it is that there'll be a $200,000 deposit made within what is roughly a week, a further $100,000 within 30 days, and that then the loans be restructured as $700,000 to be refinanced over 15 years, and for them, and it's explained by the accountant that this is affordable.
Yes.
And then the response, if we go back to the first page, is the bank has provided numerous concessions to Michael and Brendan Stanford. The bank is unable to accept the proposal.
Yes.
And then if we go to a document that we haven't looked at yet, which is CBA.0517.0118.0007. Again, I don't think this is in your exhibits. So this is an internal email of BankWest where Ms. Fragar is explaining why she's rejected the offer.
Yes.
And she makes a number of points. The first is the borrowers have had over 2 years to work out the issues. You see that?
Yes.
The third is she doesn't have confidence that Michael and Brendan will be able to run the pub and meet ongoing principal and interest payments.
Yes.
The fifth is I've not been kept abreast or involved in any of their plans or thoughts. From my point of view, they've not at any stage showed any genuine interest in selling the pub.
Yes.
And then at the end she says, while the offer of $300,000 outside of current security is pleasing, I have concerns about the conditions on which the cash will be provided.
Yes.
And if we could just clarify some matters about this, it doesn't appear, does it, as if BankWest had been engaging with the Stanfords about any plans they might have for continuing to run the pub?
I'm not aware of any, no.
And that's unsurprising because what BankWest was looking for was an exit by the sale of the pub.
Yes.
And I tender that document, Commissioner.
Emails between Fragar and Medway, 27 June 14, CBA 051700180007, Exhibit 3.126.
And then if we bring up RCD.0024.0015.0001. I'm sorry, actually, before we do that, can we bring up CBA.0001.0315.6416? So this is internal emails from BankWest. It's not in your documents, Mr. Cohen. It's being run over to you.
Thank you.
So these are internal emails of BankWest, and what is being recorded on the 30th of June 2014 is that Mr. Hornstra has received a call from Michael Stanford,
Yes.
and on the 30th of June, Michael Stanford's made the offer in the call to reduce the debt by $400,000 and restructure with BankWest.
Yes.
And Mr. Hornstra just notes declined,
Yes.
and then says may consider to pay the $400,000 to BankWest and seek a further 6 weeks.
Yes.
I tender that document, Commissioner.
Emails between Bates and Hornstra, 1 July 14, CBA 00010315
And then-
6416, Exhibit 3.127.
Thank you. And then if we go back to RCD.0024.0015.0001. So this is the email chain that was tendered yesterday. If we go over the page to .0002, and can we pop up on the one side of the page .0002 and on the other side of the page .0003? I don't know, you don't have a hard copy of that, Mr.
But
Cohen.
I'll try and read the screen.
Try to bring
for the
it over.
moment. Thank you.
And so this is the email from Mr. Medway, the accountant, to Mr. Hornstra of the bank. And you see on the, no, I'm sorry, we've got 2 copies of the same page on the screen. It should be the first page. It should be .0002 and then .0003. Thank you. And at the end of the email on page .0003, this is where Mr. Medway explains that, as had already been discussed with Mr. Stanford, the parties had secured non-repayable monies of $400,000.
Yes.
And if the bank was prepared to consider a refinance, they have that extra money to use.
Yes.
But as he says, they don't want to just roll the money into the existing debt if the bank's not going to refinance with them.
Yes.
And he then makes a proposal and then an alternative proposal as to what might be done.
Yes.
And then if we go to the top of page .0002, the response from Mr. Hornstra is, thank you for your email and I note its contents. In short, we will not engage in a further banking relationship and simply require to be repaid. And then Mr. Hornstra makes the offer that if the Stanfords want to pay $400,000 within the next 2 days, the bank may consider a further period of 8 weeks to allow the Stanfords to go and seek refinance.
Yes.
And I'm interested in understanding your view about the bank's approach at this stage, is this an approach that seems reasonable to you?
Can I deal with that in several aspects? Because I think it depends on a number of aspects. Firstly, I find the email dated the 2nd of July, I find the language of that somewhat curt and unfriendly admittedly to the accountant, but effectively to the borrower. So I find that not acceptable. Secondly, in terms of the refusal of the offer, I do understand why it was refused, and I've made inquiries in the course of preparing for today about why it was refused. And my understanding is that there was significant concern about involving a third party who was going to provide up to $400,000 in circumstances where the bank or BankWest considered that that money may very well be lost, or at least a good portion of it may be lost in the long run, given the view that the hotel was going to be unable to trade to a level that would enable repayment in due course. And for that matter, there was concern that it would be unable to be refinanced as well. So the account manager had a serious concern that the situation may get worse for the Stanfords, admittedly for a partner of Michael Stanford, if that offer was to proceed as proposed.
And can I ask, which account manager are you referring to there?
This is Ms. Frager.
All right. And so that we can, I think I asked some questions of Mr. Stanford about this yesterday, and the risk, if I put it in my way, is that they could pay $400,000 and reduce at that point in time the level of debt owed to the bank. That would be the first step of what occurred.
That's right.
And the bank might then, well, the premise of it would be the bank would refinance for a 15-year term, which was a slightly longer term than what was otherwise outstanding on the loan.
That's right.
And there would be repayments that would then have to be made.
That's correct.
But at the time, the bank had the view that this was a depreciating asset, but it was a depreciating asset because the value of the asset reflected the value of the earnings that were being made.
That's correct, yes.
And so as the asset fell, that reflected a fall in the earnings of the business.
Actually, the other way around. As the earnings
you're
fell,
right. As the earnings fell, that
Yes.
that resulted in a fall in the value of the asset.
That's correct, yes.
And if the earnings continued to fall, then it might not be possible to make the payments under the refinance facility.
That's correct.
And then you might be right back to the point that you were in to begin with, which is that the bank is then going to inevitably have to take enforcement action.
That's correct.
And at that point in time, the Stanfords, Michael and Brendan, but together with their partners, end up being worse off because they've lost their $400,000, and if the value of the property hasn't improved in some fashion, then they're also no better off in terms of paying out the debt.
That was the concern of the file manager, yes.
And in her note, she makes the point which I directed you to, which is she didn't have any confidence that they would be able to make principal and interest payments.
That's correct.
Now, I was then going to turn Commissioner to deal with some more general issues. Did you have any further questions you wanted to ask?
Not in respect of this aspect of the matter. Is it better that we break off now or start on the general issues?
I'd be happy to break off now, Commissioner, and perhaps if we could, would it be possible to resume at 1:55? That is, we allow ourselves only 1 hour.
I thought I was the slave driver, Mr. Hodge. I've been giving a fair imitation of it. Yes, well, we'll adjourn until 1:55. If you can be back at that time, please, Mr. Cohen. Yes, Mr. Hodge.
Thank you, Commissioner. Mr. Cohen, I just wanted to cover off on a couple of minor things arising from the issues we were talking about just before lunch about the offers. The discussions that you've had internally were discussions with Ms. Fragar, is that right?
That's correct, yes.
And we looked at Ms. Fragar's response to the offer. There was also the subsequent response that came from Mr. Hornstra.
Yes.
And you'll recall Mr. Hornstra took a slightly different tack from Ms. Fragar in the sense that he suggested that if they would pay the $400,000 to the bank, then the bank would be prepared to consider allowing a period of 8 weeks to renew or to refinance the facility.
May consider, yes, I think it referred to 6 weeks.
I think internally he sent an email saying 6 weeks, but then when in the actual email that he sent, we can bring it up if that would help.
Yes.
It's rcd.0024.0015.0001. And then if we go to .0002, you'll see should you, however, wish to repay $400,000 before 4 July 2014, so that's the 2 days later, the bank may consider a period of up to 8 weeks to allow you to seek refinance with the full residual debt being cleared at the end of that period.
Yes.
And I just want to make sure I understand your view about it. The view that Ms. Fragar had expressed, the concern which is bringing in a third party and having that third party put, even though it's the partner, nevertheless putting personal borrowings on the line. I think when you were explaining Ms. Fragar's view, that was a view that you approved of or shared. Is that fair?
Yes, that's fair.
And this tack of suggesting that the personal borrowings of now $400,000 be paid in and then the bank would consider a period of allowing 8 weeks to refinance, that seems inconsistent with that approach or that view of Ms. Fragar. Do you agree?
Yes, it does. And my understanding is that Mr. Hornstra was stepping in, managing that file while Ms. Fragar was on leave, so he may not have understood as fully up to speed, yes.
And is it fair to say the suggestion that he makes, which is the bank will take the $400,000 and then might consider allowing a period of 8 weeks to allow them to seek refinance, is something that you would think that probably shouldn't have been done?
I tend to think it should not have been done because of the issues that we've discussed, namely involving a third party putting a substantial sum of money into the hotel operation where the prospects for success were doubtful.
And also, this isn't even $400,000 to allow the business to continue with a refinance from the bank. This is $400,000 with the bank then being prepared to consider whether it would allow 8 weeks to seek refinance from somebody else.
That's right.
Which would mean, A, the bank might then decide it didn't actually want to allow another 8 weeks.
That would be one possibility.
And B, it might allow 8 weeks, and then at the end of the 8 weeks, it wouldn't have been possible to refinance anyway.
That's correct.
And indeed, the internal notes suggest there was no expectation that it would be possible to refinance.
That's correct.
So that then at the end of the 8 weeks, the consequence would have been the bank would have then appointed a receiver.
That's likely, yes.
And the recovery, there still would have been more than $600,000 owed to the bank.
That's correct.
And the expected recovery was going to be $600,000 or less, essentially.
Yes, that's right.
So that the bank's debt would be cleared in this scenario, or nearly cleared.
Nearly cleared, yes.
But the Stanfords would have lost both the hotel and also the partner would have lost the $400,000.
The $400,000, exactly. So the view taken, as I understand it, was that that was a worse outcome, potentially, for the Stanfords.
Well, that's, and again, we just need to be careful about this. That was the view taken by Ms. Frager when she rejected it. She just didn't entertain it at all. That's right?
That's correct, yes.
Whereas it wasn't rejected by the other person who came in.
That's correct.
But for the reasons we've just talked about, do you agree it should never have been suggested?
I don't think it should have been suggested.
And what I then want to move from, we can take that document down, what I then want to move to from that is to understand something about the incentives that work for somebody in CAM and also for somebody in the GCS.
Yes.
And I understand you address some of this, some of the detail of this in your statement.
Yes.
And we don't need to go into the detail of it, I don't think, but is it fair to say that a significant performance measure for somebody who, we'll take it at the time, as at 2013, 2014, for somebody in what was CAM and had then become the GCS, was first the length of time that they had had TAE within their portfolio, within their responsibility?
It was one of the performance measures, yes.
And what that means is a file would get transferred over from the ordinary business unit into what was CAM, and by this stage was the GCS. That's
Yes.
the first stage. And that would have a TAE, which, as we've looked at before, might not necessarily be the exact amount borrowed. It might be the potential amount
Yes.
that could be borrowed.
Yes.
And so that file moving in would then increase the TAE that was under the responsibility of the particular manager.
Of the particular manager, that's right.
And one of the responsibility, or one of the measures that was applied to a manager, was the age of files that were within their control and were adding to their TAE.
That was one of the measures, yes.
And another measure was the reduction in TAE during the course of the relevant measurement period.
That's correct, yes.
And so what that reflects is that the responsibility of a manager within CAM and what was then became the GCS was to try to move on as quickly as possible a file out of CAM. Now, that could happen in two ways. We'll come back to that. But is that fair, that they need to try to move it out of their responsibility?
No, I don't think it's correct to say that the purpose or intent was to move it out as quickly as possible. But it is correct that the intent was to move files through so that they were either rehabilitated or exited. And the purpose behind that was to ensure that the particular file manager was active in their approach and just didn't leave matters dormant or unaddressed for long periods of time.
But that means, does it not, in order to meet the two metrics we've talked about, the manager needs to focus on either rehabilitating or exiting as many loans as possible during the course of the year? No, that's not correct, because the assessment of the manager's performance would take into account
the complexity of the particular files under the control of the file manager, so that if a file was particularly complex, it would necessarily take a lot longer to deal with, and allowance would be made for that.
And just so I understand that, do you recall whether CAM and the GCS were using a balanced scorecard or something like that to measure the performance of their
That's
employees?
correct, they were.
And so was one of the components of that scorecard directly related to reducing the amount of TAE and also reducing effectively the age of the TAE within the control of the manager?
So those two elements
Yes.
were part of the balanced scorecard under the heading of risk and return.
And when you speak about the idea of taking into account the complexity of a loan,
Yes.
is that something that would feature as part of that element of the balanced scorecard or of a different element?
No, it would be part of that element of the scorecard.
All right. And so does that mean that an adjustment is made according to whether or not the loan is particularly complex or not?
Yes, that's correct.
And so it would be less important to move on a very complex loan than to move on a less complex loan?
I'm not sure that importance was the relevant factor. What was important was the circumstances of each individual loan, which in turn would have a significant influence on how quickly that loan could be either remediated and moved back to pass grade, or negotiated with the customer or enforced against.
And in the case of the Stanford's loan, as at 2014, would one of the difficulties with the loan have been that even if the money had been accepted and even if there'd been a refinance, that it was unlikely that the loan, that by itself would return the loan to pass grade?
If I understand the question correctly, refinance, of course, would not return the loan to pass grade because the loan would no longer be part of BankWest's portfolio.
I'm sorry, if it was refinanced in the way, I use it in the way that it was put in the accountant's email, which was that the loan would be restructured, as
I
perhaps
beg your
a better
pardon.
word, which is the loan is restructured so that it's done as a 15-year loan for the Stanfords to pay out the balance to BankWest, with the $400,000 money being used to pay down the capital. So if we take that as the premise, a difficulty with that would be, even at that point, the LVR would not be within the lending policy of BankWest.
Depending on the value of the property, so the reduction of the outstanding loan amount by $400,000 would obviously benefit the LVR calculation. That, however, would depend on the actual value of the property at that time.
Bearing in mind that would reduce the balance outstanding to a little over $600,000.
That's correct.
And the value being put on the property at the time was somewhere between $550,000 and $615,000.
That's correct.
So it's likely that the LVR would be close to or exceed 100%.
That's correct.
And that would put it outside of the lending policy.
That would put it outside the policy at the time. That per se would not automatically rule out that loan being restructured.
But if it was restructured in that way, it wouldn't follow that its risk grade would fall back to a point where it could be passed back to CAM.
Not automatically, no, that's correct.
And so one of the issues would be that if you're judging managers by the metric of have they managed to rehabilitate or exited a loan, this whole arrangement wouldn't achieve either of those outcomes.
It would not achieve the outcome of it would achieve the outcome of reducing TAE. It would not necessarily achieve the outcome of finalising the file one way or the other within a time frame.
All right. And my question then is, do you think that that's a problem with the way in which incentives are structured for CAM or the GCS?
No, I don't, for several reasons.
All right, and would you like to tell the Commissioner what those are?
Yes. The structure of the balanced scorecard, particularly when it comes to the risk and return element of the balanced scorecard, whilst it does contain a measure which looks at the extent to which TAE is reduced over a 12-month period, and it does look at measuring the files being moved through the system over a period as well. Ultimately, however, the assessment is made by a manager who has experience in how appropriate it is to deal with files in a certain way. And so, whilst the incentive may on its face appear as if it gives a reason for pushing a file through to closure in one form or another quickly, ultimately the assessment is made by an experienced manager who usually has years of experience in understanding how these things work and taking into account what's feasible given the circumstances of the files within the file manager's control. And so, as I referred to earlier, if that file manager has particular files which are very complex, either because of the borrowing structure or because of the loan structure or because of the circumstances of the borrower, then a manager in making an assessment of the file manager will take those circumstances into account in determining how appropriate it is to measure the employee strictly against the TAE reduction or the file turnover.
I wonder though, and this perhaps helps to move us into the issue that, one of the last issues I want to deal with you about. The issue I want to explore with you is the issue of negative versus positive incentives.
Yes.
And I think, as I understand it, the point that you're making is that the senior manager who's making the assessment of the performance of the relevant person within CAM would take into account whether a file was particularly complicated or not before effectively marking the manager down for not having managed to reduce their TAE or not having moved the file on.
Yes.
That's a slightly different thing, though, from whether there's any incentive, in the case of, say, the Stanfords, to put in place or look to put in place an arrangement that is going to prolong the banking relationship with somebody who is in CAM or the GCS. Do you agree?
Yes, I do agree. It is different. There are, however, measures in the scorecard which do incentivise a file manager away from taking excessively swift action or even, in particular, taking enforcement action. So one of the requirements of the KPIs is that the file manager minimise loss to, in this case, BankWest. And the reason that's an incentive not to rush to enforcement is because invariably when a bank enforces against a customer, it loses money. And so a file manager is incentivised to minimise loss. That minimisation of loss is usually best achieved through rehabilitating a file or reaching an agreement with a customer about how to proceed rather than going to enforcement, because invariably banks lose money when they enforce, as was the case in the Stanford's matter.
Well, the type of incentive you're talking about, which is to minimise loss, I just want to understand the point that you're making. That might well encourage a file manager as a first option to try to push the borrower to sell the asset rather than the bank entering into possession or appointing a receiver or manager. You agree with that?
That could be an outcome, yes.
And that seems to have been the approach that was adopted by BankWest in relation to the Stanfords.
Yes.
But again, that seems to be a slightly different thing from incentivising the file manager to look to try to restructure the arrangement with the borrower and thereby prolong the relationship between the borrower and the bank.
No, I don't necessarily agree, because prolonging the relationship, well, if I can go back a step, the best outcome for a bank is for a customer to successfully repay the loan. So an incentive for a file manager here would be to potentially restructure the loan in such a way that there was a greater certainty that the customer would successfully repay the loan in due course. That would be a successful outcome for the file manager and the customer and the bank.
Now, what I wonder then is, apart from that incentive, which is to avoid making loss,
Yes.
is there any other incentive, as you see the balanced scorecard, to try to find a way to restructure the arrangement with the borrower in a way that avoids having to force an exit by the borrower?
Yes, another element of the scorecard, which from memory was on average worth about a 20% weighting, was what was called customer focus. And that was a requirement that a file manager in GCS conduct themselves with the customer so as to satisfy the customer, and I'm talking about the external customer, satisfy the customer, to avoid complaints from the customer, and to manage a customer's expectations along the way. So there was a positive incentive to engage well with the customer.
And how, for that 20% for the customer relationship, how did that get measured? Was that by surveys of customers, counts of complaints?
It was a combination of some quantitative measures, which were numbers of complaints or number of compliments, and then qualitative measures, which was the assessment of the manager, the assessment of relationship managers who would obviously have the ongoing relationship with customers, particularly if it was a jointly managed file. So it was a combination of both quantitative and qualitative.
And the qualitative, just so I understand, is the assessment by the relationship manager of the performance of the CAM/GCS manager, is that right?
No, not the assessment, but input from the relationship manager. So, for example, the manager of the CAM's file manager would seek input from various people as to the performance of that file manager. And one of the people they would seek input from would be the relationship manager. But I should stress that would be primarily where the relationship manager and CAM have ongoing involvement with each other in connection with the customer.
And if you think about the things that in this Stanford's case you think were either unfair or not done as well as they ought to have been, and we take those in turn. So the first is the provision of the dealing with the bank, between the bank and the customer about the appointment of an IA before the appointment was made.
Yes.
Are there parts of the balanced scorecard which you think incentivise the CAMS manager to do that, or the GCS manager to do that?
I think the customer focus element of the scorecard is an incentive, yes.
That's the 20% done by input from the relationship manager and the count of number of complaints or compliments.
Yes, and the assessment of the GCS file manager's immediate manager.
Right. And similarly, when it comes to engaging with the customer about the outcome of the independent accountant's report,
Yes.
is there an incentive that you see in the balanced scorecard to encourage that sort of behaviour?
Yes, again, I would put that in the category of the customer focus element of that scorecard.
The 20% for the
Yes.
customer focus.
Yes.
And when it comes to communicating the bank's approach or the bank's concerns more generally about the file and how it should be managed, again, do you see an incentive within the balanced scorecard to do that?
Yes, both within the customer focus element of the scorecard and also the risk and return element of the scorecard. The risk and return element of the scorecard included an obligation on the file manager to manage risks associated with the portfolio of files that they handled. And one of the risks, obviously, is that matters between the bank and the customer do not proceed well. For example, through a lack of engagement or a lack of communication or a lack of expectation management. Similarly, the risk and return element of the scorecard required compliance with policies. So to the extent that a file manager did not comply with policy, by engaging with a borrower, then there was an incentive in that component of the scorecard.
Now, I then want to step further back away from that and just try to put this in the context of your role now as the Chief Risk Officer. Is the formulation of the balanced scorecards something that forms part of risk management for the bank?
Yes, it is. The scorecard that we use within risk management is derived from an overall scorecard approach used throughout the bank.
But when it comes to each individual section's balanced scorecard, is that something that your risk section has an input into?
I'm sorry, do you mean in the design of the scorecard? Yes. The design of the scorecard is generally determined at a bank-wide level, so the elements of the scorecard, or the categories, if I can call it that, of the scorecard are determined at a bank-wide level. Then when that is translated down into an individual area such as risk management, the detail behind each element is then designed specific to the activities undertaken by that business area, in this case risk management.
And in this particular case that we've looked at, wearing your hat as the Chief Risk Officer, do you see any failings in terms of risk management in relation to the file?
In relation to the Stanford matter? So the failings, I think, as I've mentioned, are definitely in connection with customer engagement. Yes, I think there should have been stronger communication with the customer and more transparent communication with the customer around the investigative accountant's report and the issues that concerned BankWest.
Is that though, sorry, the issues that concern BankWest?
Yes, the issues around the trading, the profitability of the hotel, the issues that concern BankWest about the future ability of the borrowers to repay the debt.
And that customer experience issue, is that a risk management issue or is that something separate?
Well, in this particular case, the communication with the customer was undertaken by members of the CAM team, and the CAM team were part of risk management. So yes, it is part of risk management's responsibility.
Right. Now, then if we step back again even further and you consider some of the things that the Commission has looked at in this module and in other modules in relation to misconduct that has been identified by CBA, does that reflect, in your view, an issue in relation to risk management?
I think there are some issues that are quite complex because they involve a number of balancing of different factors, sometimes competing factors. Some of those are very specific to customer engagement, and as I've said, I think there were shortcomings in respect of how the Stanfords were engaged on a number of aspects. However, there are some much broader and complex issues around how files such as this are handled, and I don't want to go into too discursive an answer, but there are three broad issues that come to bear in these types of cases. One is prudential obligations to appropriately provision, which is born out of the fact that it's depositors' money that is being lent. So 61 cents of every dollar that we lend belongs to depositors. And so the prudential obligations are very focused on protecting depositors. Those in turn drive prudential standards about provisioning, for example. So there's one level of driver for risk management to focus on prudential standards. There's a second element, which is the role that banks play in funding the economy. And by that I mean Because Australia is a net importer of capital, banks have a role in recycling capital. And recycling capital occurs through, for example, one loan finishing and a decision by a bank, for example, not to renew that loan, but to lend the money to someone else, another business. And that's a very important role that banks play, but it does actually raise some difficult customer conversations sometimes when a customer is hoping or even expecting that a loan will be rolled over. The third element that competes with those two is customer interests. And I don't mean depositors' interests when I say that, I mean borrowers' interests. Because sometimes the obligation at the prudential level to protect depositors' funds, and that can translate into, for example, taking action against a borrower in order to protect depositors' funds and satisfy prudential obligations. It might also mean that one should recycle capital, but that can have a devastating effect on the individual borrower, particularly if it's a small business. The intersection of those three competing factors, almost like a Venn diagram, if you will, lies right at the heart of some of the judgments that have to be made in risk management. And we seek to get those judgments right, but that's not always the case, and those judgments are not a black and white issue, they are often subjective.
Just step back for a moment from the lending decision to make a loan to the Stanfords and think about, as you know, CBA has over the course of the last few months acknowledged, both here and in other forums, misconduct of various kinds.
Yes.
And to take a specific example that's been dealt with in this hearing, you know that there was an acknowledgement in relation to the charging of what I think is referred to as double interest, seems to actually be slightly higher than double interest, but double interest in relation to certain overdraft accounts,
Yes.
just as one example. But there are, as you know, many others that have been identified.
Yes.
And I just want you to focus for a moment on whether you see some intersection between the performance of the risk function within the bank and the extent of those identified problems.
Yes, I do. And particularly in two areas. Those are the areas of operational risk and compliance risk. And if I can deal with each of those.
Yes.
Operational risk manifests itself when a bank acts in a way that exposes itself to some loss. And in the case of, if I can take the example of the overcharging of interest, that is an issue that occurred, as I understand it, as a result of some system or administration problems. A bank with a sound operational risk system would seek to avoid those issues arising in the first place by by doing a couple of things. First, identifying the risk. So in this case, identifying the risk of a system overcharge. Secondly, designing controls that would mitigate or eliminate that risk. And thirdly, testing those controls to see that they're effective, and if they're not, improving the controls. Now, those three elements are the role of an operational risk function in a bank.
And I'm sorry, just before you move on to compliance risk, did you say the way in which you see an operational risk is something that exposes the bank to some loss? Is that
to a risk of loss,
right,
or a risk of reputational harm, or to expose customers to loss, or customers to some form of harm? Yes.
And then you then were going to make a comment about compliance risk?
Yes, I was just going to finish quickly on operational risk, and that is simply to say that the operational risk team within risk management has responsibility for, not for doing all of that, but for certainly assisting the business, because operational risk mitigation sits within business lines as well as in the risk management team, so the two have to work together. That's our lines 1 and 2 that we were referring to yesterday, working together. Compliance risk is similar. Compliance risk involves identifying compliance obligations So legal obligations, regulatory obligations, guidelines, prudential standards, etc. Working with the business to design how compliance will be achieved. Putting in place mitigants to avoid non-compliances. And that's designed to avoid obviously legal and regulatory penalties, but also to avoid reputational harm that can flow from those incidents occurring in the first place.
And so does it follow then from what you're saying, if you're identifying some of the issues that have been faced by CBA as intersecting with the risk functions, that there has been some failure of the risk function over time?
Well, I think it's fair to say that the risk function has not always performed as it should have. So in that sense of a failure, yes. I think we've acknowledged that at CBA in a number of ways in the recent times.
And to assist the Commissioner to try to work through this more general issue, what are the things that might have contributed to that failure?
I think we need to be quite specific about what the failure is. I could probably talk for much longer than you'd be willing to listen to me about aspects of this, but if we could be a little bit specific about the failures, I could.
Well, as I understand it, what you're positing is that there's two types of risk that the risk function is or ought to deal with, which are operational risk and compliance risk, which have then led to or have then been intersected with some of the issues that have arisen over the course of, or been revealed over the course of the last year or so.
Yes.
And I had thought that you were suggesting that what that reflected was therefore some inadequacies, which CBA is now seeking to address, in relation to how its risk function deals with operational risk and compliance risk. Is that
Yes,
right?
that's correct. Well, the risk function and the organisation as a whole.
And those aren't issues that are specific to any particular incidents of misconduct. They're more general than that. Is that right?
They are more general to that, yes.
And so if we take the things that might have contributed to it, is one of them concerned with remuneration incentives?
I don't believe so, no.
Okay. And just to be clear by what we're each meaning by that, you mean you don't think that has contributed to any failure within the risk function, or you don't think that has contributed to any of the problems that have arisen?
I don't think that's a factor in the risk function, no. No.
And what about more generally in relation to the problems that have arisen, bearing in mind, for some context, one of the things that is obviously of continued interest both in this Commission and outside of the Commission is the Sedgwick report in relation to incentives.
Yes.
So I just want to be clear, you're not suggesting you don't think remuneration incentives have some relevance to the problems more generally. You're just referring specifically to the risk function.
Yes, that's correct. That's correct.
All right. And in terms of the culture then within the risk area, are there issues that you have identified now that you are responsible for risk in the culture of risk management at the bank?
No, I don't believe so, other than in one respect.
And what is that?
I think in the past, potentially, the risk function has not been sufficiently challenging of the business. In other words, I don't think the risk function has always challenged as vigorously as it otherwise might, and as a result has potentially not put the business to a greater level of proof about the way it is doing things.
Is an issue that you've identified within, or a problem that you've identified with the carrying out of the risk function, being able to recruit the right people to work within that, your risk section?
It is the case today that recruiting is difficult. That's primarily because there is a higher demand than has been in existence in the last few years for suitably qualified people, particularly in operational risk and compliance risk and financial crime compliance. So it is more difficult to recruit today. I think financial institutions generally are much more aware of the need to have better risk management functions. The pool in Australia for highly qualified risk professionals in numbers is not deep. And so there are some difficulties at the moment in recruiting, particularly in those three areas.
And in terms of if I use the term major risk initiatives, does that have a meaning to you?
Yes, it does.
All right. Would you if you explain to the Commissioner what would be meant by the term major risk initiatives?
Commissioner, since coming into the role in July 2016, I carried out an assessment of initiatives that I thought needed to be undertaken in order to address shortcomings in some of the ways in which risk was managed, and commenced a program in early 2017 identifying 9 key areas where I felt that the risk management function needed to substantially improve its approach. And so I think that might be what you're referring to, Mr. Hodge.
And could you give some examples of those types of 9 areas?
Yes. In no particular order. One of the areas was what we call 3 lines of accountability. So a reference back to the 3 lines of defence model that we were discussing yesterday. 3 lines of accountability is, I identified that there was a lack of clarity between the business line and the risk function as to who did what. And my view has been, and it remains, that it's very, very important for the risk function to be performing true line 2 activities, not business operational activities. And it's only by performing true line 2 risk management activities that a risk function can concentrate on what it should be doing, and to do that very well. And previously there had been a blurring. So that's one. Secondly, we've focused very much on policy simplification, and in particular focusing on credit policies, so that for the lenders in the business, they can access policies very easily, credit policies that is, so lending policies. They can understand those policies very easily. They can apply them very easily, so that our standard of lending improves. I have one of the initiatives is about the operational risk and the compliance risk operating model. And by that I simply mean that we changed our model so that the operational risk team spanned the entire Commonwealth Bank group as a single team, rather than in the past being a team that had a small central or group team with separate operational risk teams sitting in each business unit. And we did the same for compliance. In fact, we pulled compliance out from under operational risk and made it a standalone risk type with a standalone leader. So those are some of the initiatives.
And have some of them been easier to implement than others since you've come in? Or some of them, let me put that a different way. Some of them you have implemented already?
Yes, we have. Our risk appetite strategy, for example. So I felt it was very important that the organisation have a very clear view on what its risk appetite was. And whilst we had a risk appetite previously, it was quite a lengthy document. The average employee would not be able to pick it up and easily understand what was the organisation's risk appetite in areas such as profit, capital, liquidity and conduct. And I wanted to have some very clear statements in the organisation adopted from the board, or by the board, sorry, and then cascaded through the organisation. Now, we have completed that. We completed that in August of last year when the board adopted a new risk appetite statement. So that I now categorise as achieved and now part of business as usual. And as part of business as usual, we refine the risk appetite statement according to changes that we experience along the way, such as financial crime compliance, for example. Others are still in train, such as the 3 lines of accountability and the policy simplification.
And have there been challenges that were unexpected in implementing some of those initiatives?
I would say that one challenge in respect of 3 lines of accountability has been that as we have gone into individual businesses and looked very closely at what the business people do and what the risk management function does, and as we have identified which activities are not risk management activities, then comes the question of moving those activities out of risk management into the business. We've not encountered differences of opinion as to whether the activities should sit in the risk function or the business. Where we have encountered challenges is in actually moving those people and deciding where they were going to sit, how they're going to be run in the business. Not insurmountable challenges, and challenges that we are dealing with, but they do take some time.
And do you have the view that the reforming of the risk management function within CBA has taken longer than you would have liked to after you took control of it?
No, I think I took a very realistic view that making these changes would take a significant period of time, some less time than others. One of the initiatives was to significantly revamp our risk systems, and by that I mean our computer systems and the systems that we use for measuring and reporting on risk. I always took the view that that was a 3 to 5 year project because significant investment would be needed, and it takes time to invest in large projects like that.
So from your perspective, none of the major initiatives that you've attempted to, or that you have set about putting in place, have, in terms of the time they're taking any different timeline than what you had expected?
Not particularly, no.
All right. And the last thing then I want to ask you, just again stepping back even further from this, is the general function of what risk is about. Is it your view that the fundamental purpose of the risk function is to avoid bad things occurring, and if they do occur, minimising the consequences, or is there something more to the risk function than that?
No, there is something more. I think it's important to understand that the risk function doesn't stop things happening necessarily. Things happen in the business lines as well as in support units. But the people in the business line or in the support unit are there on the ground day to day dealing with matters. The risk function's role is to help those business lines identify the risks and then put in place controls. So the primary role of the function is to be able to identify risks, to raise those risks, to then help the business control those risks, to test whether those controls, or at least have an overview of the testing of those controls to see whether mitigation steps are working, and then if they're not, helping redesign so as to help avoid the risks. When a risk does occur, when an issue does occur, yes, the risk management function has a role in helping to minimise the fallout, whether that be an operational fallout, a financial fallout, a customer impact, is to help minimise, and the risk function works closely with the businesses in doing that.
And is the function of risk management then in connection to the long-term reputation of the institution to assist business units to try to identify things that might have some negative consequence for the long-term reputation of the institution, and if those things are identified, to either take steps to prevent them occurring or to minimise the effect of them? Is that a fair summary of?
I think that's a fair summary, with an emphasis on taking steps to try and avoid the issue arising in the first place, because particularly in context of conduct, for example, conduct risk. Once the conduct has occurred, then the reputational damage, the financial loss, the customer harm has started to flow already. So the emphasis therefore needs necessarily to be on preventing issues in the first place through accurate identification and strong controls.
Commissioner, I don't have any further questions for Mr.
I
Cohen.
just ask some other matters arising out of that same general subject matter. Mr. Cohen, you spoke of revamping the risk system and that was a task you foresaw as occupying years rather than weeks.
Yes.
Are you familiar with the fact that immediately after appointment I wrote to, amongst others, CommBank, asking for submissions identifying misconduct?
Yes.
And are you familiar with the submission that CommBank then made on 29 January?
I saw it just before it was lodged, Commissioner, yes.
Yes. As you know, I wrote after that and other submissions were received a further set of inquiries to Commonwealth Bank and others asking the bank and others to identify misconduct events that had been identified in the preceding 5 years. Are you
Yes.
familiar with that fact?
Yes, I am.
Did you see the response that was made to that inquiry?
Yes, I did.
It was the response to the effect that that was not information that the bank could readily supply.
That's correct, yes.
Are you familiar with the fact that during, I think it was the first round of hearings, Commonwealth Bank, having heard counsel assisting open the matter in a particular way, towards the end of that round of hearings produced 2 tables of identified misconduct relating to the previous 5 years?
Yes, I am.
What, if anything, does that course of events tell me about Commonwealth Bank's capacity at the start of this calendar year to identify events including breaches of law in the immediately preceding 5 or perhaps 10 years?
Commissioner, I think it tells you that the state of our systems that recorded and aggregated instances of misconduct, such as those that were eventually provided to you, were not particularly advanced. They were not particularly well connected. The difficulty that the bank experienced was that various incidents of misconduct were recorded on different systems in different business units without necessarily being all encompassed in a single business unit. In the risk management function, we have a tool that you may have heard of called Risk Insight.
I've seen Excel spreadsheets generated by that, yes.
Yes, they're not always the easiest documents to navigate.
Yes.
Yes, I share that same difficulty if it's any consolation. The Risk Insight tool is meant to be the single repository of all relevant issues.
Look at the printout and you discover that somebody has logged that at branch X, customer service officer was rude to customer, sitting alongside an event that, at least if it happened to be recorded entirely accurately, would be of a
serious,
rather more serious kind.
I agree. And so while the Risk Insight tool seeks to be the sole repository, it unfortunately has not always been. It is highly dependent on people logging issues into that tool. That is partly the function of the risk management team, partly the function of business people. However, the great difficulty we had is that the ability to use that Risk Insight tool in order to, for example, search and therefore aggregate and deliver into a report instances of misconduct is extremely limited.
I understand that, and that's not the detail of risk insight that I want to stay on. It is to move from that to an understanding of control of regulatory and reputational risk, and whether the course of events that I have described bears in any way upon the way in which compliance risk and reputational risk was being managed, at least at the start of this calendar year, in Commonwealth Bank, and we'll come in a moment to what, if anything, changes about that. But first, does it tell me anything about the state of play at the start of the calendar year?
I think it does, Commissioner.
What's it tell me?
So apart from the inability to aggregate at a tool level, so setting that aside, I think the other thing it tells you is that the forums, the governance forums, whether it be at management or board level, for escalating and bringing to attention reputational and conduct issues has not been strong enough in the past. And such a forum and all of the lower level forums that feed up into it would provide a better flow of information, a better flow of escalation of serious issues, reputational issues and conduct issues. And I think also would lead to a better ability to aggregate, because one would have records of meetings and issues put before meetings and be able to aggregate all of those looking back.
But to also to observe whether there is in truth a real problem that is bubbling away out in the branches or in the field.
That's exactly right. And I think one of the issues at the executive management level that we have lacked, and this has been pointed out by APRA, is that we have lacked
To the issue.
an executive non-financial risk committee or forum for considering non-financial risks. Because I think the organisation as a whole is relatively, not perfectly, but relatively good at logging and tracking and measuring financial risks, but the same emphasis has not been placed on non-financial risks such as conduct and reputational issues.
Now, you spoke of the need for policy simplification, particularly in relation to credit policy, where people knew where to go when they got there, could understand what they found, and having understood it, could then apply it. Do I capture at least an important element of the essence of what you were saying?
That's the essence of it, Commissioner, yes. And we chose credit risk not because it was an area crying out for particular attention, but because we felt we needed to deal with areas one by one, and so credit risk was our first one.
Now, what about compliance risk?
Yes.
An institution like Commonwealth Bank is subject to a very large number of quite distinct and distinctive regulatory provisions.
Yes.
Is it an area that would permit, is it an area that would benefit from simplification of the kind broadly analogous to that you've described in credit policy?
I think in the area of compliance risk, Commissioner, the issue that we have faced in the past is we have not had a thorough enough identification of compliance obligations. So one of the things that we are addressing at the moment as part of our revamped compliance team is to establish a compliance register for every single business and support unit so that it is very clear exactly what obligations must be met. That then leads to the second stage, which is how do we satisfy those obligations? So that is our effort at the moment. So I don't think it quite leads to yet a simplification of policy. I think, Commissioner, it's probably fair to say that we have lacked compliance policy to some degree. We did have compliance policies, of course, but I do think we needed a degree more compliance policies to deal with issues, and then, as I mentioned, a much greater level of detail about what obligations needed to be met.
Because underneath the very large raft of regulatory provisions we see. I wonder whether at least many of them can be seen as reflecting only about 4 or 5 relatively readily grasped ideas. 1, don't mislead or deceive. 2, don't act unconscionably. Or if you don't like the word, don't act unconscionably, be fair.
Mm-hmm.
Should I? Various ways of putting it.
Yes.
3, is it fit for purpose? What's the other warranty that's ordinarily implied? Fitness for purpose and
Due skill and care.
due skill and care. Do your job with due skill and care. Thanks, Mr. Sherry. And then your responsible lending obligations. Now, strip a lot of the detail of the legislation and you won't capture all the nuances in those 4 or 5 ideas. But for the bank officer on the ground, is that something that the bank officer needs to be told? Are the informing principles that lie behind compliance?
Yes, Commissioner, I think so. I think perhaps the tendency in the past has been to, not deliberately, but has had the effect of clouding some of those basic principles through multiplicity.
Yeah.
And as I say, I don't think that's been deliberate. I think it's been an additive process, and layer upon layer upon layer is introduced, is absorbed, rules and policies are set around that new layer, and it is sometimes difficult to distill the very essence of the fundamental obligations out of all of that that set of policies, procedures, processes, etc.
I don't pretend for a moment that the distillation that's just been tossed off the cuff is the last word on the subject. My question is whether an institution in the position of CBA, as part of its risk management, one could, but more relevantly I suspect should, think of moving down that path, or is this to push down a path that is simply not useful?
No, I don't think it's unuseful, Commissioner. I think it requires a sense of returning to the basics.
Yeah.
And I think in the recent report issued by APRA, you'll be aware of the focus there on the organisation asking itself the question, should I?
Yeah.
And I think that is a return to a very important basic element that in that layering that I've just referred to has sometimes, I'm afraid, been a bit lost. And again, I don't think it's deliberate on any part, but I think it has been the result of an accumulation and maybe a case of not seeing the wood from the trees to a certain degree.
Mr. Hodge?
Nothing from that.
No.
There's no re-examination, Commissioner.
No. Thank you very much, Mr. Cohen. You may step down. I think you are excused. Is
Thank
he
you,
not,
Commissioner.
Mr. Hodge? He's
Commissioner-
excused.
He is excused, yes, Commissioner.
Thank you, Mr. Cohen.
Thank you, both.
Commissioner, can I do one thing before we change over to the next case study, which is at the conclusion of, in fact, I said one, there's 2 things I'm going to do. One is at the conclusion of Mr. Van Horen's evidence last week, he was cross-examined on a document which couldn't be brought up on the screen and I think was not tendered at the time. So I understand by consent with CBA, we can now tender CBA.0001.0281.0806.
And what description do I give it, Mr. Hodge?
Can we bring it up? CBA.001.0281.0806. CBA.001.0281.0806. It's a chain of emails, Commissioner. The 12th of
Emails 12 January 17 between Reeves, Leo and others.
Thank you, Commissioner.
With that, doc ID becomes Exhibit 3.128.
Thank you. And then the other matter is, Commissioner, in the preparation for this module, we asked each of ANZ, CBA, NAB, Westpac, Bank of Queensland and BankWest to provide statements setting out an overview of their respective business lending, including various monetary thresholds for small, medium and large business banking, their policies and number of business customers, and the proportion of their lending comprised of business lending. Can I now tender each of those statements? We're not calling the witnesses. So the first is a witness statement of Isaac Rankin from ANZ in response to rubric 3-2, and the document ID is ANZ.999.009.0052.
That document becomes Exhibit 3.129.
The second is a witness statement of Joanna White of CBA in response to rubric 3-1. The document ID is CBA.9000.0035.0001.
That document becomes Exhibit 3.130.
The third document is a witness statement of Howard Silby of NAB in response to rubric 3-4, and the document ID is WIT.001.0034.0001.
Becomes Exhibit 3.131.
The fourth document is a witness statement of Alistair Welsh of Westpac in response to rubric 3-3, and the document ID is WBC.900.001.0464.
And we didn't tender that when Mr Welsh was giving his
I
evidence.
believe so, Commissioner. No.
Then that becomes Exhibit 3.132.
The fifth document is a witness statement of Douglas Snell of Bank of Queensland in response to rubric 3-6, which is BOQ.001.0071.0001. Again, I don't believe that was tendered at the time Mr Snell gave evidence.
Becomes Exhibit 3.133.
And the last document is a statement of Sinead Taylor from BankWest in response to rubric 3-1, which is CBA.9000.0036.0001.
I thought we did deal with Ms Taylor's.
There was a different witness statement of Ms Taylor that has already been tendered, Commissioner.
There were two of her, Commissioner.
So has it gone in or not gone in?
One's gone in, one hasn't.
And that's the one I'm tendering now.
But I was just querying, Commissioner, whether Mr Williams' statement has been tendered.
No, that's the Part C statement, Commissioner. So there's another round of Part C statements that will be tendered tomorrow.
Yes. The last mentioned statement of Ms Taylor will become Exhibit 3.134.
Thank you, Commissioner.
And now we changing
Yes,
brigades at the bar table. I'll come back at before 3:10.
Thank you, Commissioner.